interest and attorney fees. Defendant filed an answer denying the claims and asking for some discovery. So it was just a generic denial answer. The claim isn't huge, $1,474.91. Good morning, Mr. Royce.
Good morning.
We've started off with a thud this morning. We had 3 cases so far. No one's shown up. You're the first people to actually be. I think the cases may have resolved under the radar, and to further complicate things, the civil clerk isn't here today, so maybe she got some orders late on Friday that didn't make it into the files. Anyway, Ms. Delgado, would you be willing to speak privately in a breakout room with Attorney Royce and discuss this matter?
Yes.
Mr. Royce, is that agreeable with you?
Absolutely. Thank you.
Let me set up the breakout room. This is particularly adapted to these civil pretrials where the parties can meet privately. So I will put both of you in a breakout room, hit the button that says join. I will wait here while you're talking about this, and then we'll see how we proceed. So I'll be right here.
Great. Thank you.
Thank you. All right. Well, again, we're off like a herd of turtles, but I think maybe they'll make some progress. The next one is a 945. It's another one where the defendant claims that they are in a debt consolidation program. And then the last matter, the 10 a.m. matter, is a motion for summary disposition. It's always a little difficult to explain that concept to lay people. I guess at least we're doing something. Again, it's just me and a talking head. Lock the camera again. Well, that was fast.
Yes.
All right. How did you do?
I think we have a resolution where we're going to, I'm going to prepare a conditional dismissal, Your Honor. I have her email address, and I'm going to prepare it immediately after we get off the hearing, and we'll submit it to the court as soon as we can.
Very good. What are the terms?
Ms. Delgado would be paying just the amount pled for in the complaint, $1,474.91, in payments of $400 commencing August 28th and continuing thereafter till the amount is paid. Obviously, her last payment is going to be substantially less, but.
Very good. So no cost, no interest,
no cost,
no attorney fees.
No.
Ms. Delgado, that's several $100s worth of costs and fees that they're waiving. You're going to pay it in blocks of $400 a month, and that'll pay it off in about 5 months, perhaps.
Yes.
800, about 4 months. Okay, very good. And so the conditional order of dismissal means the case will be dismissed and it won't show as a judgment on your credit. And that is a benefit to you. So he will send you that. I will tickle this matter 10 days. Very good. Are you still at Green Lawn?
Yes,
Okay. And he has your email address.
correct.
Do you have any questions?
No, not at the moment.
All right, well, you guys were quick to resolve that. I appreciate all you being here on time. You both get on with your day. I've got another case waiting in the waiting room, and we'll address that one. Ms. Delgado, best of luck to you.
Great.
Thank you so
You
much.
two have a great day.
Mr. Royce, thank you. All right, now I've got Matthew Vasquez next. He's in a repayment plan. So this one isn't for 10 minutes or dead air. Good morning, sir. If you would unmute your mic, that would be helpful.
Did that work?
Yes, very good. Thank you. Thank you for being here on time. You're actually a little early. Let me put you in the waiting room while we wait for the attorney to show up.
Okay.
Don't go away. This one is more substantial, $9,306.91. Wish my screen would stop blinking off. Five minutes. It appears this defendant is also at work. And this is very handy for people that are technically able to connect by Zoom. They don't have to take the whole morning off, drive here for a 2-minute hearing, and then miss a half a day's work. Also, the attorneys can zoom in from wherever they are. This attorney of record is from Farmington Hills. And they can do this, and the last case took that attorney 5 minutes. Three minutes. This is another one where he gets set up a payment plan. So they've been working on the echo, and it just may not be reconcilable. They've done as many things as they could with settings and microphone settings, and we turned off the sound on the television set. We're in a great big room with a very high ceiling, and it echoes. Good morning once again, Mr. Vasquez.
Good morning.
You're zooming in from work?
No, I'm at home.
Okay. The plaintiff isn't here yet. It is 9:45. This matter is entitled Fortress Investment versus Matthew Vasquez. The file number is 26321GC. The plaintiff has claimed damages in the amount of $9,326.94. Mr. Vasquez responded to the lawsuit with a letter he entitles Written Answer, filed on May 18th. I'll read it. I enrolled all of my debt into a debt relief program before I even missed one payment. I thought they were taking that out of my debt relief for a year and a half. The plaintiff gave me an offer to settle outside of court, and I'm going to accept their offer. That was as of May 18th. They're not here. Mr. Vasquez, did you reach some sort of agreement with this plaintiff?
Yeah, I've already made 3 $1,000 payments to them.
Wow. And that would have been May, June, and July? Or
Yeah.
June, July, May, June, and July?
No, it's June, July, and August. I just did a payment on the 3rd.
All right, so did you sign some sort of a consent judgment or something that reflected that you would make that payment?
Not 100% sure. My debt relief company has been doing a lot. I'm not sure exactly what they're doing.
All right. Well, that's a substantial payment. So your intention is to pay essentially $1,000 a month for 9 months?
Yes. Yeah, I'm really surprised we got to this point because really, I don't know what my debt relief company was doing. If they needed more money to help settle my debts, they could have reached out and asked for it. I don't know why. I don't know why.
Well,
we
if
made
you're
it this far.
capable of doing this, you're better than a lot of the people that get sued. They aren't here. Perhaps there's some sort of a document floating around out there. The civil clerk isn't here today. And I hope she doesn't have a bunch of these consents in the in basket somewhere, but you are here, they're not. You're paying $1,000 a month. I'm going to release you. I'm going to tickle this matter for 30 days to either find a judgment or do a dismissal, as you've reached a payment agreement. So I commend you for the large amount you're paying on this debt. Eventually you'll get out from under it and you can keep your own money. But they aren't here. There obviously is some sort of a resolution that has not been reflected with an order, but we'll see if we can find the order. Anyway, I'll let you get back about your business. And thank you for being here in a timely manner and giving some background.
Yeah, no problem.
All right, you're good to go. Thank you.
Yes, thank you.
There's an interesting ceiling there. Well, I don't know too many defendants that are paying $1,000 a month plus the debt consolidation, but that will certainly get this debt paid off. Again, I don't know what the deal is. Last matter is set for 10, which is 11 minutes from now. And again, I just have more dead air. It is a motion for summary disposition.
V is in Victor. Last case on the docket, I believe.
All right, what are we doing in this case?
Judge, on CR 38, Mr. Mosley and Mr. Roberts have been plead guilty of misdemeanor vandalism in count 2. Count 1, the aggravated burglary will be dismissed. It will be on 1129 probation. That'll be concurrent with 2024 CR 48.
Martin, raise your right hand. Let's push on the road.
You solemnly swear from the testimony you're about to provide will be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
State your full name for the record.
Michael Varner.
Mr. Bonner, you're here today on a 2-count indictment. You've heard your lawyer talk about what the agreement is, but have you seen or been shown a copy of the charges, talked about them with Mr. Bunyan, you and he discussed the range of punishments you're facing as well as any possible defenses you might have? Well, it's indicated that you want to enter a plea of guilty to count 2 and have count 1 dismissed. You understand you have a right to plead not guilty to all charges and to have a speedy and public trial by jury.
Yes.
You understand you would have the right to have a lawyer at trial and have one appointed if you cannot afford your own. You understand that if you were at the trial, you would be presumed to be innocent until such time the defendant state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and therefore it would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and Mr. Bunyan could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena. You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that by entering this plea of guilty, you're waiving your right to a trial to an appeal. All I'm going to do is, I'm sorry. You understand if you went to trial, you were found guilty, you could have an appeal and have a lawyer appointed to help you in that appeal. You understand that all I'm doing is to prove what you and your lawyer have worked out, that you're waiving your right to a trial. You understand that's going to result in a misdemeanor conviction, and that's going to be on your record in the future to make more severe the punishment you receive if you're ever being convicted of a crime. You understand everything I've explained to you. Do you want to plead guilty according to this agreement and waive your right to a trial?
Yes, ma'am.
You understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty.
Yes.
You understand that if you plead guilty, the state could ask you questions about this offense, and if you answer those questions under oath and on the record and in the presence of your lawyer, your answers could never be used against you in a prosecution for perjury if I determine that you're lying under oath.
Yes.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will? You understand I have to have facts to support finding of guilt in your case. So are you guilty of this misdemeanor vandalism? What happened?
So much from porch and I vandalized her up.
All right. Anything further necessary for the state?
No, Your Honor, that's correct. As far as restitution, we did not hear back on restitution from.
All right. Are you satisfied with your attorney services?
Yes.
You feel like Mr. Runyon has done a good job of representing you confidently?
Yes.
Mr. Runyon, you know of any reason we should not enter this lawyer?
No, Judge, but something we did not discuss. I just want to be sure he's clear his probation that he was on, that he violated, starting over. He's not as part of this agreement. And we need to reset this case today. If you'd contemplate that, I think the court would reset it. But your probation starts today that you've been on.
The only thing I is, since I've been incarcerated, my family relocated to a different state, and so I'll be homeless out here. I need the chance. My wife and son, they've been in the same house at the same job since June when I got arrested, and so they're in Michigan.
We've already discussed this. He's not eligible for a transfer, but he's indicated to me in the past that there's a transitional house here in Dover that you can go to. So that's where we stand with the transfer out of state. It's not eligible at this time.
I have no job or no way to pay for that.
Would you rather go ahead and just serve it out in jail?
How long would that be?
Well, it's 11/29 with credit for time served, so I don't know how long it would be before they said you had served it. When did you, he was on probation or had a sentence before?
Yes, it's before the new charge.
How long you been in jail?
June 28th, last year.
Last year? Give him credit for time served, he served his sentence.
It's true.
Would you like to just serve your sentence rather than be placed on probation?
I don't know about to be okay with that.
He has a 3-year sentence for the possession of firearm.
Well, this one was going to be served concurrently with what he had previously, which means he's going to get credit for that time since June of last year, which means he served more than 11 months and 29 days. So this court finds he has served his sentence. He will not need to be placed on probation. We're going to turn you loose and you go where you want to go, except that you're on probation for a felony. You got to adhere to those terms. Now, they told me you're not eligible for a transfer. So as I've told you, I've said before, the only way you can get a transfer out of this area is to have the Department of Corrections approve a transfer to another state. And they have to be willing to accept it. So right now, we don't have that. So we're going to show that you have served this sentence and that you are concluded with this case. Thank you.
Thank you, Judge. Thank you for calling me.
Mr. Atchison is here. We need to take that matter up. I guess we need Ms. Donald back here. All right, we're taking up a Houston County case again, but we are set for trial in this case, I think next week, is that correct?
Judge, I believe all of this, it's about 2 weeks away. And Judge, the purpose of filing it now, we had initially set today's date for motions in this matter. However, based on the motion to continue to file on behalf of Mr. Cook, we don't have the forensic analysis back yet on the cell phone. That motion was initially granted by Judge Wallace. It could be quite some time behind.
What motion was granted by Judge Wallace?
The motion for additional funding to secure a company that could do the forensic analysis. He granted that motion, Judge, but it took me quite some time to find somebody AOC approved that would accept and take on the responsibility of analyzing that phone. We have found that now. I just don't have it back yet. And so I would be I think that it would be a disadvantage to my client if we moved forward without that being complete.
All right, so essentially what you're saying is that the victim's cell phone is the one that you're talking about
That's correct.
in this case. And what is there on that phone that you think would be relevant to the trial, which is set next week?
Judge, the in and out phone calls, the messages between the parties, I think are very relevant. I think that it also, if nothing else, Judge, I think it helps us prepare a more proper defense for Mr. Cook moving forward as opposed to not having.
So are you involved in this case?
The co-defendant's attorney.
She has Mr. Dash.
And do you agree with what Mr. Atchison was saying?
I do, Your Honor. I've kind of been riding his coattails on this a little bit because my client is not court appointed and doesn't have the funding for this. So I've been kind of tracking along with Mr. Cook to be able to get the funding to get that phone down.
Have you gotten the funding approved?
I have, Judge.
So it's just you've not been able to find someone?
Well, it took quite some time to find a company that would actually, I ran through, well, this is short, but I will say that. They were the only one within this area that agreed to take it. I got a couple of times refused for.
All right, step aside, let me hear from the state.
Your Honor, to give you some context on this phone, Mateo Bazelon, it's his phone. Back in spring of 2025, I took his phone to Homeland Security. The issue we had was he had given us a passcode. It's an iPhone, but the passcode Mr. Mateo had given us would not work, would not open the phone. So I went to Homeland Security. I dropped the phone off there. They were able to break into it a little bit, get some data, but it was very limited. There were no messages between him. There was no messages at all, from my understanding. I've given that phone dump to both defense counsel. They weren't able to do a full extraction. They were able to get a few things off, maybe some pictures, but nothing like an extent I would take a phone and get a full extraction. Argument I'm saying is if the Homeland Security, U.S. Homeland Security can't get into this phone, I don't know who would be able to get into this phone. Another thing, I don't know about the relevance. The facts bring out the communication, and this has been testified to at the juvenile transfer hearing and prelim. The communication between Mr. Cook and Mr. Mateo Bazelon was all during FaceTime prior to this incident. I don't know if there's any way to extract FaceTime videos or messages in an extraction. So I don't know if we could begin any of the communication leading up to this event anyways, because it was all done via FaceTime. According to the testimony, I believe that the defendant, Mr. Cook, and the victim, Mateo, in previous hearings. So, Your Honor, I don't know if the company that Mr. Anderson is going to be able to get anything out of Mateo's phone if U.S. Homeland Security can't get into it. I don't know who can. I don't know if there'd be any relevance because I don't know if there's going to be any messages leading up to this event that occurred. So I would ask you to deny the motion.
Just briefly, as follow up. What I was saying is accurate. Mr. Baldazon did provide a code to his phone, but I think that anybody familiar with iPhones knows that if you give the code, the phone should open. And so that leads into a different argument wherein I don't think he's gave the proper code. And if we're going to move forward on something, then I want to address every angle possible. That's a very serious charge. And I think that Mr. Cook is entitled to that.
Well, the charge against Mr. Cook, and I assume that Mr. Dasher, is attempted first-degree murder, or attempted murder, and it's a Class A felony. There are other charges as well, but obviously the issue of what interaction has occurred between the victim and the alleged victim and the defendant is a big part of what the jury will probably need to know leading up to that. The biggest issue here is that there's been a court order entered by Judge Wallace to authorize the funding for this particular endeavor that you're in. I don't find there's any fault on the part of the defense lawyers in trying to get this, because I'm sure it is difficult to find a technological company that's willing to do that. And as Mr. Woodall says, none of us are sure exactly what's in that phone or what you're going to be able to get. But erring on the side of the defendant's right to present a competent defense, I have no choice but to grant your motion to continue to allow you to. We're going to set it the next term of court. You'll have that much time to get it done. I assume the state has a reciprocal discovery request so that if they obtain any of this information, you're.
I don't know if I'll file one, but I'll give a file.
Understand that whatever information's on that phone, the state's going to have a reciprocal. I think, my calendar. And our next term of court is in December, right? This being a Houston County case. I showed that we have the state versus Dillon Ray Estes that set for the 15th. Is that still a go?
Probably a day and a half, just to be on the safe side.
If we set this case for the 17th,
I'd say this would be a 2-day trial.
you think this one is a 2-day trial?
I don't agree with that. Day 14.
So state versus Dillon Ray Estes, you're saying is a 2-day trial?
I would say a day and a half, yeah, just to be on the safe side, Your Honor.
Well, probably in December is obviously the holidays. So. What about the 28th and 29th of December, in between Christmas and New Year's? Y'all not doing anything during that time, surely? I say that at the risk that I'm going to be referred to as Judge Burks Jr. So in January, I am back in Dixon.
Your Honor, I don't know if we have anything set for trial in Stewart County on that.
In December?
Do we want
I've
to
given you the 8th and 9th and 10th.
see if we could do this use of precedents? We just need to check and see if we have anything set. I'm not certain.
Why don't we set it for the 9th and 10th of December?
Good with that.
Yeah, I already have stuff set. Final hearing for that.
What day?
9th, and it's been moved twice. I think I'm fairly certain my client would maybe work. Okay. I guess.
Okay, we move the Dillon Ray Estes to the 8th and 9th and give you the 6th, 15th, and 16th, and if necessary, 17th.
I'll no issue with that. I'll do that.
All right. We need, who is the defense lawyer in the Dillon Ray Estes?
That's Caroline Wright. Confirm with her.
Confirm with her that we need to move that to the 8th and 9th,
Yeah.
or the 9th and 10th, either one of those combinations. And we'll put your case on 15th and 16th, and if necessary, the 17th. This is all in Houston County, right? Okay. Good thing I write my calendar in pencil.
Smart move.
Anything else?
Judge, thank you.
I'll draw the whole thing,
Judge.
Thank
Please do. All right, we're ready to go back into the regular call of the docket for Stewart County. Mr. Flanagan, what do you have?
Judge, can you hear me?
I'm not hearing you. I don't know if you're muted on your end or if you got to turn your phone.
I'm getting an echo.
Can you hear me?
I can hear you. Can you hear me at all?
I can hear you now.
All right. Nina Norfleet, who's in the courtroom. General Allen and I are going to go to a September date. We're still negotiating and hopefully have a resolution, but I don't know what that date is, Brooke.
That it just for possible pleads. I think we just need one more month.
You want to set it September what?
Is it the 14th?
September 14th.
I'm just waiting to hear back from some of the parents.
September the 14th.
And then if we don't settle it, we could set it for your honor.
All right.
Thank you, Judge.
All right.
And Ms. Norfleet is there and she can leave. So
all right, Ms. Norfleet, you're here, but you can leave.
thank you, Judge.
Anything else?
That's all.
All right.
Thank you.
Now we can get off to the call.
Yes, call for
Okay.
Okay. Yeah, let's take those.
All right, first case on my docket.
Last, he had some wait for him arraignment and plea of not guilty.
Mr. Flanagan, we can hear you, so you need to.
Judge, if we could, their general speaking.
All right, who do we call?
Mr. James Allen, first on the docket.
James Elisha Allen. Alan, you have filed a pro se motion apparently for a sentence clarification. Actually, you're saying motion to fix defendant's jail credits and for defendant's actual release date. There's really no way I can do it. If you were sentenced by Judge Larry Wallace, so I'm going to appoint the public defender to assist you in determining what your actual sentence credits are so that you can know when your sentence is expired or you've served your time. So they will look up those. Mr. Clemens is here. We're going to appoint him to step in and take over looking at your case to determine whether or not that you've served the amount of time that you think you have. Okay. And get you credit for everything, but he's going to have to look into that. So we'll put you on September docket just to make sure. Okay. September the 14th, Mr. Clemens.
Thank you.
All right, let's call the next case.
Next case is 2024 CR 10 Kelly Babcock.
She entered a plea back in April of 2025, but we delayed the disposition to allow her to be furloughed to the Hope Center for a 1-year program. And have you finished the Hope Center?
Yes, Your Honor, I have. I'm still currently in aftercare. I graduated June 9th this year. And I'm still in aftercare center affairs.
I talked to Mr. Potter, Your Honor. The state's recommendation would be just to revoke and reinstate her. She does have her certificate
Right.
today. We want her.
Well, she's already pled, so what we're going to do is, today was just for a sentencing hearing because you'd already entered a plea. So what I'm going to do is as a part of the judgment in this case, is to order that you be revoked or serve your sentence, but based on your completion of the Hope Center, not having any further problems, we're going to reinstate you back to probation. You did what we asked you to do, so we're going to give you that credit. All right? Good luck to you in the future. Do you want this back?
Yes.
Okay.
We can make a copy.
Huh?
Make a copy.
Let's make a copy and give her back the original. If you'll wait a little bit, though, you'll have your original back. Okay?
Yes, Your Honor. Thank you.
Congratulations. We have an inmate, Jennifer Barber, but I don't see her here.
Next case is 2019 CR 33, Jennifer Barber.
Inmate, they have both females up. They're gonna do like that. Those first and then they'll bring the females up.
Yeah. This next case will be Paul Davidson.
I'm gonna pass the Paul Davidson case until we can, I'm gonna review that file and I'll have that file. Let's go to the next one, which would be 2025 CR 5, State versus Joseph M. Duty. Mr. Duty, you're also wanting to clarify your pretrial jail credits. You're indicating that you don't believe that you received the appropriate amount of pre-sentence jail credits. Is that correct? Yes, sir. All right, Mr. Clemens, I'm going to have to appoint you to represent Mr. Duty to see if you can determine what credits he's entitled to. And I can't look at it and tell anything about it, but they're pretty experienced in this. Mr. Clemens is a good lawyer. He'll look into it and he'll let you know whether or not you are not receiving all of the credit to which you think you are. Okay? Thank you. All right. Let's set it for that September 14th day just to keep it on the docket. The next case is that one that we have set for 11 o'clock for a plea. Is that correct?
Yes, Your Honor.
Then I'll move to 2025 CR 65, State versus Richard Gordon of Stevens. I'm sure Sonny Stevens was the attorney.
Let me see if she stepped into the hall. Second call is Your Honor, I'm not sure.
All right.
I know that she has Circuit and Dixon. Oh, there you are. I'm so sorry. I've been zooming.
Your Honor, if you would entertain a second call, they're about to pull up emails and that's why I'm waiting on for reasons.
Put it on a second call. We're doing the inmates one. Sorry. 2023 CR 6, State versus Robert L. Kaiser. We've heard from his attorney, Mr. White.
He's here, Your Honor. He just stepped in the hallway.
Okay. This is for a sentencing hearing.
It is. It can take a little.
All right. Mr. Kaiser, if you'll just have a seat, it'll take a little bit of time for us to get to you, so let's take up some of the shorter matters. 2016 CR 60 State versus James A. Merriweather.
Your Honor, it's my case. Mr. Merriweather's here. He's got a violation of probation, which we'd like to plead to today. If we have to revoke to serve, he's
Mr. Merriweather, raise your right hand. Let's place you under oath.
You solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record. Mr. Merriweather, you are here today charged with violation of community corrections. I want to make sure you understand your rights. You understand you have a right to plead not guilty to the charge and have the state the state would be required to plead to the legal standard that you're actually violating your community corrections probation. You understand that you would have the right to have a lawyer, to have one appointed if you cannot afford your own, which I've done with the public defender. You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by pleading guilty, you're waiving your right to that hearing, to that appeal. All I'm going to do is revoke you to serve your sentence and give you credit for all your time. You understand everything I've explained to you. Do you want to waive your right to the hearing and enter a plea of guilty to the charge of violation of community correct? Then I find you guilty, will need to be revoked to serve your sentence with credit for all your time served. Thank you.
and I have the jail credits. I'm going to give him.
That's fine. Twenty 2024-45 State versus Patrick Hardiman Rogers. I think he's filed a pro se motion for sentence clarification.
Yes, Your Honor. This is a case kind of similar, I'm guessing, to the two others I was just appointed to, except I've been appointed to this a while back and hadn't been able to make any progress on it. The situation is he's been revoked to serve a 2-year sentence, and he's got day-for-day credits as far as we can tell. That's just about 61 days short, does that sound right, of having served the full 2 years. When I was appointed to this case, Judge Mash told me, well, get his sentence reduction credits, find out when his release date's supposed to be, report back. However, I haven't been able to get those sentence reduction credits. And when you look up his case on Tinfoil, the website that normally show things like sentence information, felony offenders, it's blank. It's got no start date, no end date. He tells me it used to have an end date on there, January of this year. January 31st. But then it went blank, and we can't figure out what to do. I'm at a loss. I've told him as soon as he's a day late, I could file a habeas, I suppose, but I didn't want to go that extreme. And if there was any better option.
So he pled to 2 years Department of Corrections on attempted aggravated burglary, 1 year on theft, and 1129 on vandalism. Is that correct?
That's right, John.
And that was back in November of 2024. So how about I just say that he has served his sentence and find that he is entitled to, he served more than 75% of his sentence, it seems to me. So
yes,
if he's been in jail continuously since that time, so why don't we put an order down that just says that his sentence has been completed according to his release eligibility?
That sounds good, Your Honor.
State have any opposition to that?
No, Your
Right.
Shall I draft that order, Your Honor?
You draft an order that says that the court, it came before the court for determination of whether he gets any jail credits that he wasn't entitled to, that I found that based on the sentence that was imposed and the length of time he has served, that he is entitled to be released.
Yes, Your Honor.
Thank you. Mr. Rogers, don't go back to the jail today and tell all the other inmates that you're going to get released just because you filed a motion, okay? 2025-071 State versus Martrell F. Seabury. Mr. Clemens, that's your case.
Yes, Your Honor. In fact, we have a settlement on this. May I pass this up, please, Your Honor?
All right, Mr. Seabury, I've been handed a document indicating that you want to enter a plea of no contest or no contendere to count one aggravated assault on a first responder, a Class C felony, and you would receive a 6-year sentence as a range 2 offender, suspended to supervised probation, credit for time served, waive of any fines. You would have count 2 dismissed as a part of that agreement, and you get credit for September 1, 2025 until today against your sentence. Raise your right hand. Let's place you under oath.
You solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record. Mr. Seabury, you're here today on a 2-count indictment. You've heard me go over what your agreement is, but do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury? You understand that a plea of no contest means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they step to the microphone and tell me what they say you did. And I'm going to use their version of those facts to find you guilty according to this agreement. You understand that? You understand, as I've said, that you can plead not guilty and have a speedy and public trial by jury. And if you did that, you would have the right to have a lawyer, to have one appointed, which we've done with a public defender. You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and no verdict would have to be unanimous before you could be convicted. You understand that if you went to trial, you and Mr. Clemens could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena. You understand you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty,
I guess he didn't. I mean, I don't know.
He had a fight.
He didn't like me or whatever. I was in the restroom and he approached me, wanted to fight me. I tried to walk past him. Whenever I tried to walk past him, he shoved me in the stall and then hit me. And whenever he hit me, then I did hit him back once he started to assault me. But I did try to walk away from it, considering I was so close to the door.
Who was your judge in Butler County?
Oster.
What's your girlfriend's name?
Skylar Day.
And she was your co-defendant in this case?
Yes, Your Honor.
You still having, I guess the no contact order was lifted between you and Miss Day, correct?
Yes, it was, Your Honor.
She's on aisle C.
Yes, Your Honor.
Who's supervising Miss Day?
I believe it's Officer Ruff.
You're right, it is. Has she had any problems?
Not that I'm aware of.
I'm interested in getting this restitution paid, Officer Fisher. Here's what we're going to do. Mr. George, I'm going to continue you on community control at this time. You will be held in the Warren County Jail pending the payment of the restitution in full and pending a new drug and alcohol assessment, mental health assessment. I want to get that done. So as soon as those are done, I will release you from the Warren County Jail. Release you from the Warren County Jail on electronically monitored house arrest. Where will you be living?
I will be living in Harrison, I believe.
All right. You're ordered to comply with any recommendations made in the new assessment, and the monitor will remain on at your PO's discretion. Ms. Tranter, is there anything else? Looks like you have 76 days jail time credit as of today.
I don't have anything else, Judge.
Officer Fisher?
Nothing further, Your Honor.
All right, Mr. George, I think you need some help. You have a terrible record for your age. I mean, I don't, certainly have an alcohol problem and perhaps a drug problem too. So we're going to try to get you some help. But you need to, if what is being represented is true, I'm going to know soon enough. But you certainly don't want to pick up new charges by cutting off your monitor again, right?
Yes, Your Honor, that's for sure.
Right. Ms. Diefenbach, is there anything else?
No, I did not believe so, sir.
All right, that's all. Thank you.
Thank you.
Hey, Dean.
Thank you very much.
Thank you.
All right, this is case number 17CR33257, the State of Ohio versus Terrell Bryant McNeil. Ms. Tranter is here on behalf of the State of Ohio. Ms. Tranter, I have received from your office, signed by Assistant Prosecutor Carl Harris, a nollie of this case. Do you have anything for the record?
Nothing for the record.
All right. At this time, then, the court is going to grant that nollie presented by Mr. Harris. Thank you.
You understand what your charge said.
Yes, Your Honor.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor.
An agreement has been reached where you would be pleading guilty, but not found guilty. That's 500.
500 is correct, Judge.
Let me use the airheads numeral system.
Understood. We blame the path, Judge.
I would blame it on being left-handed, but I don't think the court would have a response for that problem.
We're in it together.
Understood.
% of us are left-handed, 1 out of 7. If you're on Jeopardy, you've got the answer. The other one. So you would not be found guilty, but you would be placed on deferred or unadjudicated probation for up to 10 years, fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is this your understanding of the agreement?
Yes, Your Honor.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
How do you plead to this? Guilty or not guilty?
Guilty.
You're pleading guilty voluntarily because you are guilty. Yes?
Yes, Your Honor.
Show you what's marked as a State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence without objection. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, and you read it. You are guilty of the crime charged in any less included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, Your Honor.
State's Exhibit 1 is made a part of the record for all purposes.
Yeah.
Is a pre-sentence to a court way?
Yes, please, Judge.
Do this, Judge.
Stand. Nothing further. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, based upon State's Exhibit 1 and your guilty plea, because you are pleading guilty voluntarily, knowingly, intelligently, correct?
Yes, sir.
But the court is not going to find you guilty of this offense at this time. I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You do well, it will be shortened to 3 1/3 years. There will be terms and conditions of probation which are normal and customary for this type of offense. You must pay a fine of $500. Now, I'm going to take a moment on this one. Let's see. You uploaded 12 videos to the Google Drive depicting prepubescent males, that's young children, performing and receiving sexual acts, unclothed, exposing their genitals. And you admitted downloading videos from a social media site X and uploading them to your Google Drive account. And your cell phone was seized, and there was a video of possible child pornography still on the phones. So this just a sidebar. Possessing or child pornography is not a victimless crime. Each time the child who is depicted, unless it's a problem, even if it's AI made, and a lot of that is out there. But if these there's nothing to state that these aren't real people anyway. Each time they are viewed from the internet or downloaded with their victimization, it victimizes them in the internet forever, and they will be victimized the rest of their lives. And we aren't talking about people who have voluntary acts. These are prepubescent. These are children. Each time you view it, you pass it along, even though it may be serving your prurient interest, which is inappropriate and immoral, plus illegal. It's harming these children. How do you undo their harm? You're enjoying yourself, apparently, at their loss. You're going to go to jail. I can put you in jail for up to 180 days. How much punishment should someone receive when they are victimizing children? The law limits me at 180 days. You're going to be ordered to do 180 days in a county jail as a condition of this probation. Also, the probation office is, when I sign these documents, there's going to be a moral reclamation therapy program, but child pornographers, if people don't accept and take part in watching or in viewing child pornography, child pornographers don't have a business. They run out of money. They quit doing it. It takes the pornographer and the recipient who accepts it and then views it to make it work, to make the crime work. And so you can't say that you didn't harm anybody, because we are. I mean, it's a common known fact that you've harmed people, children. These are children, people, and it's in the internet forever. I mean, there's not much we can undo with that, except don't subscribe to it and don't play into the pornographer's plan to make money off of it and to have people to proliferate the continuing victimization of the children who are viewed. It's in there forever. It's in there forever. Go ahead.
Mr. Weatherly is scheduled to return to school this week.
He can do it on weekends. He can do it on weekends.
It's not local.
I'm sorry. It's what it is, Tom. So here's the deal. Just everybody can then go to another school and not have to pay a price. How do you undo the victimization of children? You can't undo it. You have to pay a price, a penalty. And it's just not deferred probation and a fine. So you have to. I'm setting an example like I do in all others on child pornography. This court has zero tolerance on child pornography. Everybody knows that. And Tom's going to represent Mr. Kelly's a great lawyer, but he's not going to find an expert who's going to come in and say he doesn't deserve to be placed into jail, because every expert will tell you proliferate the harm. It's not just the people who take the pictures and throw them on the internet. It's the ones who download them and then use them. Shame on you. And I feel sorry for the kids. These are children who are being harmed. Not on my watch. Not on my watch. I'll work with him, Tom, but he's going to do 180 days. That's a message I'm going to send to everybody. I send that same message for everybody who's in child pornography who gets deferred. He's got to work it out somehow. Where are you going to school? You two on? That's college, isn't it? You're in college?
Yes.
You know better. You're going there for an education to be wiser. This isn't wise. Yeah, he's got to work it out.
Would the court please hold and let me at least hold it?
What do you want to
do? I'd like to address it.
You can address it all day long. He's going to 180 days in the county jail, one way or the other. And all people, if I open this door, all they're going to do is go, oh, let me get in college somewhere and I'll go and I won't have to pay the price. He's done the deed, has to atone. That's the way it works. It's the equivalent of a spanking when we were children. But you pay a price. I don't feel sorry for you. I feel sorry for the children who are victimized here. It's just terrible. Can you imagine the child seeing that when they're adults, or the family members saying, oh, there he is again on the internet forever, and people are downloading and enjoying themselves at their victimization? No, that's not going to happen. I'll give you a week to figure it out if you come up. I'll reset it 1 week, but he's going to go 180 days in jail unless you can convince me otherwise. But nobody's ever been able to.
We certainly try.
I'm sorry about it, but once again, I'm sorry for the children who were victims. That's who I feel badly for. Not you. You made a free choice to take evil versus good, and you knew it was wrong. You know that's evil. Fine. I'll reset 1 week for review, but then be ready. You're going to do 180 days one way or the other somewhere in a confinement to a time. All right. Okay. Did a reset. Thank you, Judge. Jason Altman, John, John, Britt, you ready?
Sure.
What do you have?
I have 2 weeks, Judge.
Who are they?
The other ones I'm going
I'm sorry.
to recess. I have Mr.
Belden. I got Connor Belden, 3 cases.
Yes, sir. Mr. Walls for plea.
And Walls. Okay. Is Walls one? Let's do Damian Walls first. 24 CR 223A. Damian Walls. Thank you.
He's got
2 judges.
He's got 2 judges.
None.
One's kinder than the other.
Well, New Orleans PD had a big day yesterday. I was signing warrants all day.
I have it here. I do. Sorry, if you have
Kids came out of Houston, and got into some big trouble in Nederland, and those guys were apparently ready, willing, and able to respond.
It's NPR. He already has some rent.
Wish they wouldn't be doing that because I get called in church while I'm a lector. Sorry, folks, I got a blood warrant. Okay, Damian Walls, this week. Got 2 cases here in the miracle sequence. Are they both NTRPs? Yes, sir. All right. 2 cases are called 24 CR 2228 and 24 CR 2343. Each are first amended motions to revoke probation. The state of Texas versus Damian Walls. That is you.
Yes, sir.
Present with Mr. Turk, your attorney. The state's attorney is here and probation officer is present. Does the defendant waive formal readings of these first amended motions to revoke probation in each of these two cases? Can we proceed in summary?
Yes, sir.
Sir, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. I'm going to do this at the same time, okay? Can we take these together? Because they're similar in their wording. They're separate thefts, but they're thefts on the same day and the same punishment. Each of these first amended motions to revoke probation similarly allege that on October 14th, 2025, in this criminal district court of Jefferson County, Texas, you were sentenced to 2 years in the state jail, probated for 5 years for state jail felonies of theft in each case. Is all of that true and correct, sir? Good. Okay. Yeah. Eight violations. What are we doing? What are we going on?
Just one, Judge.
Just one what?
The first
Just number one? Is that right?
That's fine, Judge.
Allegation one, in each of these cases similarly allege that you failed to report to the probation office as directed on or about November 25th, 2025, January 27th, March 6th of 2026. And those violations are violations of condition 4 of each of your probation orders. And is all of that true and correct as it is alleged?
Yes, sir.
Are you pleading correct voluntarily to allegation 1 in each of these first amended motions to revoke probation?
Correct.
And because they are true as they are alleged?
Yes.
You understand the voluntarily knowingly made plea true to 1 or more violations of probation. That's enough to grant these motions to revoke probation.
Yes.
Your probations can be revoked and you can be sentenced to no less than 180 days up to 2 years in state jail in each case. You understand?
Yes.
Knowing that, do you insist on pleading true today in each case?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes.
Agreements have been reached where your probation would be revoked in each case and sentenced to 15 months in a state jail to run concurrently. Is that right?
Yes. Yes.
Is that your understanding of the agreement?
Yes.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
You know what I'm looking at? What's the restitution on these? I want victims to get paid back. I don't want them to just sashay on by doing time and then the victims are out the money that he stole from them. Does he still owe or did he pay them off? I don't have that. I'm looking at the motion and it doesn't address a money violation. Did you pay the restitution off? No, I didn't think so. Probationers never seem to. But the people always wonder why they are going to get, the defendant is going to get less than 2 years when they still owe, when he still owes these poor people who were victims for the money that he stole from them. And, you know, I have a hard time trying to explain how that is fair because it doesn't seem fair to me.
Judge, the restitution is $3,130.59.
In which case?
2343.
What about the other? There's none in there? Okay. It's what is 3,001?
$130.59.
Are you able to pay that? Sir?
I was paying to.
Well, you cannot. What do we do about that? Do we tell the victims they're so out of luck? I mean, I can put it on the judgment, but we all know that never gets paid. You don't have any way of paying this $3,130? Because this is not a 2-year sentence. It's less than 2 years, which is the maximum here. But I know what the victims say. Why is he getting a break of 9 months off and I'm stuck? He stole $3,130.59 from me and he's getting out early. Where's my money? You know, that's hard to explain to them because it's not fair. I mean, they're getting victimized twice. You stole from them and then you're sashaying out of there early. Are you able to, is there some way you can pay this $3,000, this restitution, or someone on your behalf?
I'm going to try.
Did you get do you have somebody who can pay? Because I'm going to go along with this, but not when the people aren't going to get paid. Because once you're sentenced, they never get paid back.
Did you get the furniture? Judge, it looks like from this one, he used a check to buy furniture, but I don't think he actually got the furniture.
Okay, the restitution order says restitution in the amount of $3,130.59 at $150 per month. That's what I signed. That's what everybody signed on. That's what everybody agreed to. You can't undo that now. And it's in the judgment that I signed in October of last year. Everybody went along with it. Has he paid anything on? Has he paid any restitution at all? No. Well, I'm not going to. People aren't going to be stolen from twice. Come on. You're not going to pay this unless you pay it while you're in custody. I'm not going to let you out.
I suspect it was probably covered by insurance, Judge.
Until you can, well, then my insurance, if it's State Farm, my insurance just went up. The insurance doesn't print money. The people who are the customers pay for the monies. When we get our, the premiums, we pay premiums, and that's pays to the big money locker. And then when people have losses and they're insured properly, they take money out of the locker that we have put in. That's the way it works. But I'm not going to, no, I open the door for one, I open the door for everybody. And tomorrow somebody comes with a big restitution and 10 people are here. He owes me. Are you kidding me? He's going to get out early and he owes me and we're not going to get paid. But here's the deal. You made a promise on this probation in the first place, and it's in there. You promised you'd pay it. These are all terms and conditions that we set. And I've received a copy. I agree to follow all conditions imposed upon me. You didn't. All right. I'm not going to pay you. I got to deal with it. I'm not going to just look at a victim and say, I just don't have any empathy for you, because I do. I feel sorry for every one of them. And I'm up here making symbolism by what goes on. You have to pay. You have to pay the loss for these people to put them back in hole, and it's $3,000. That's why you went to prison, or you placed on probation, and that was a requirement. And you've been on probation for a while and haven't paid $1. So you pay that $3,000. You get that restitution paid as soon as possible. We'll bring you back up here, and I'll follow these deals. You can, but you signed on it. You made a promise. I just read to you. You made a promise, a deal that you didn't follow. So I'm going to be unilaterally giving you something when the victims are going, wait a second, what about me? The victims are hurt in this. from this court. Come on.
So is the judge stating probation so he can get out and go pay it?
Oh, there's, I don't know where, he's in jail right now. He's in jail clothes. Well, he's going to go wherever he went before. I'm not going to let him out. He's in jail for something.
Is the court inclined to take a longer sentence on the revocation? Or are we?
Y'all figure it out. I'm going to let y'all are the lawyers, y'all figure it out. All I'm demanding is the victims get paid back like you made the promise you would do. You made the promise almost a year ago and you hadn't paid one dime. Yeah, that's all. Victims, everybody needs to reread the Victims' Rights Act. That's important. There are sanctions for not following the Victims' Rights Act. People entitled to get paid back when they're the lost for voluntary intentional crimes. So just come on. And then I'm willing to work it out. Who else do you have?
Belden, Judge. Belden to be a plea.
Which one?
Mr. Belden.
Belden, Connor Belden.
Yeah.
Does he need to go in front of you?
NCRP's on all.
Y'all straight to right hand, swear or from. Right thumbprint.
No questions.
Roll call.
No questions.
You get it one more time.
It's kind of the job description.
You test the evidence, hold a stick to his person.
That would be a question. It's the system.
Yeah, don't roll it.
Do you want to be taken?
Yeah, he's on probation on all of these.
Yes, sir.
Right. Okay, we call brief cases, all the state of Texas versus Connor Gabriel Belden. That's you?
Yes.
With Mr. Turk, your attorney, and the state's attorney. Does the defendant in these three cases, in this 23 CR 210, 23 CR 211, and 24 CR 1657, does the defendant waive formal readings of these motions to revoke probation in each case? Can we proceed in summary?
Yes, Judge.
In summary, sir, 23 CR 210, we'll do it numerical. It states that on or about December 9th, 2024, in this court, you were sentenced to 10 years in prison, probated for 10 years for the third-degree felony of evading arrest or detention with a motor vehicle. Is all of that, by the way, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hands. Is that statement I just made all true and correct?
Yes, sir.
And in 23 CR 211, in summary, that motion to revoke alleges that also on December 9th, 2024, in this criminal district court, you were sentenced to 2 years in the state jail, probated for 5 years for attempting to take a weapon from an officer, I guess a law enforcement officer. Is all of that true as it is alleged?
Yes, sir.
And then finally, in 24 CR 1657, in summary, this alleges that also on December 9th, 2024, in this court, you were sentenced to 2 years in the state jail, and that was probated for 5 years for the state jail felony of burglary of a building. Is that true and correct?
Yes, sir.
Back on this third-degree felony, first in 23 CR 210. An agreement has been reached where you would be pleading guilty, sentenced to 4 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Just a minute. PCR 211. You were again sentenced to 2 years in the state jail, probated for 5 years on that case. And allegation 1 also states that in that case that you failed to report to the probation. Is that what we're going on?
Yes, yes, Your Honor. The state would abandon all but allegation number 1.
Okay. And it's the same allegation as before. And what we're going to do third here in a moment, you failed to report to the probation office as directed on August 19th, September 3rd, September 17th, October 14th, as in the previous case that we went over, allegation 1. And is that true and correct as it is alleged?
Yes, sir.
Are you pleading true and correct to those violations in these 2 cases that we've discussed here this morning, 23 CR 210 and 211? Are you pleading true voluntarily and because it is true as it is alleged?
Yes, sir.
You understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation is enough to grant a motion to revoke probation. Your probation can be revoked and you can be sentenced up to 10 years in prison in the evading arrest or detention with a motor vehicle case 210, and up to 2 years in the state jail for attempting to take a weapon from an officer, a state jail felon. And do you understand all of that?
Yes, I understand.
And in the final case, 24 CR 1657, in summary, that alleges that on December 9th, 2024, as the other cases, in this court, you were sentenced to 2 years in the state jail, probated for 5 years for the state jail felony of burglary of a building. Is that true?
Yes, sir.
And allegation 1 is the same allegation as the others. You failed to report as directed to the probation office August 19th, September 3rd, September 17th, and October 14th of 2025. And that is a violation of your probation order. Do you understand?
Yes, sir.
And are you pleading true to that as well?
Yes.
In this case, voluntarily, knowingly, intelligently, and because it is true.
Yes, sir.
And understanding that if voluntarily and knowingly made more violations, it's enough to grant a motion to revoke probation. Your probation can be revoked and you can be sentenced.
Yes, sir.
Up to 10 years in prison. The 3rd-degree felony 210, and up to 2 years in the state jail on each of the 2 cases in cause number 211 and 1657. Knowing all of that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Let me ask this. You got confined in the state jail for 24 months. Can we put 2 years?
No objection, Judge.
Is that okay?
Yeah.
On the 2 state jail felonies to run concurrently with the first case of 4 years, right?
Correct.
So we got the 3rd-degree felony 210 will be a 4-year sentence, and the other 2 state jails are 2-year sentences each, and those all run concurrently. Is that what you understand, Mr. Belvin?
Yes.
Okay. Just when they see 24, what you don't want is for somewhere along the line, they go 24 and then they put years. See, when you're in your back, it can happen. And they don't mean to, but yeah, they don't. Yeah. You don't get caught. More than you bargained for, right?
Yes, sir.
And again, I'm going to follow these agreements in each case. And because I'm going to do that, you have no right of appeal of each of these cases. Do you understand? Sir?
Yes, sir. I understand.
Months, and that is a requirement of your probation order in each of these cases. You have admitted this voluntarily, knowingly, intelligently. That is enough to grant these motions to revoke probation by a preponderance of the evidence or greater. These motions are revoked and your probations are revoked in each case. In the third degree felony, 23 CR 210, evading arrest or detention with a motor vehicle, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 4 years. And in clause numbers 23 CR 211 and 24 CR 1657, the attempting to take a weapon from an officer and burglary of a building, respective. These are both state jail felonies. Your probations are revoked in each of those cases. I'm following these agreements. You are hereby sentenced to confinement in the state jail for 2 years, and all of these sentences shall run concurrently. Do you understand what has happened, sir?
Yes, sir.
All right. Anything else? I thought you would be given credit for all time you have served in accordance with these cases. Thank you. That is all. I don't know what it would be without paperwork. And not a lot of it. Okay, that's. I'm sorry, Milton. Okay, all right, fine.
And got revoked, so. He doesn't like my.
Wait.
He was on probation on the second month and then got revoked.
Well. Okay, but these are new cases. So he was on probation and then those probations were revoked. Were they felonies? Under
one of them was, yes.
Okay. Is he eligible? He's not eligible for probation? His fortune?
From you.
Sir?
From you.
But not from jury.
Well, what's he going to do? A jury trial? Okay. All right. Which one of y'all want to go first on? The protective order or the burglary?
They're both the same set of facts, so yeah, I think we can do the
same. No, one says no.
Evidently, you're really happy.
Hold on, these are a year apart. How can they be the same set of facts?
I'm sorry, Judge. Maybe I got them wrong. I thought they
one says October 7th. Nope,
they're both same.
I'm sorry.
Yeah, exact same time.
The order that he violated allegedly was a year before
yes,
that.
Correct. That's correct.
Okay. No, that's for trial.
Whenever we want to put them. Go back to the
Okay, we'll put it for trial. Tydrick Davis. Status, whatever that is. The status.
We're ready, asking to place on file about the judge. She comes to the defendant of the gentleman that pled last week.
Okay, it's capital murder.
Whatever they want to allege.
Well, I mean, what is the indictment? The indictment says capital murder.
Capital murder.
Okay.
Grand jury indicted, yeah.
Okay, then that's set for trial.
Thank you, Your Honor.
We'll move that. That gets an accelerated time. Thank you.
Yeah, sure. Forwarded.
Is Langston still on his way? Where'd he go? Oh, he's back there. John?
Yes.
Robert Alderson? Is that familiar?
That sounds familiar.
Altman.
Judge, I think you'll need, I've got it. Right here, Judge.
It's not strong. It's just Alderson.
That you? Alderson?
Alderson.
Robert Alderson?
Yes.
That you, sir?
Oh, no, sorry. That's, you say Alderson or Altman?
ALDERSON. Robert J.
Yeah. Your Honor, this is a relatively new case compared to what we got. This is our first thing to make a appearance in court. I am talking with Ms. Moore. If I get a little more time, we have some offers on the table. I have some things I want to talk to her about, see if we can get something. But
Yeah, 4 cases, right?
yeah, 4 cases.
Okay. In 26 CR 485, 26 CR 486, 26 CR 887, 26 CR 1162, all styled the state of Texas versus Robert J. Alderson. That's you, sir?
That is not my true name.
I don't know. What would your true name be?
Please insert the suffix, the second Roman numeral 2. I am the second. That's my father's name.
Oh, he's the second.
Okay. That's the way your birth certificate reads?
Yes, birth certificate, social security card, yes, sir.
Robert J. Alderson, the second.
Yes, sir.
And that's your dad's name?
Well, not the second.
Robert J. Alderson, though?
Joseph, yes, Joseph. Yes.
Why isn't it a junior like me? I'm a junior. And the Roman numerals, that's unique. You can do whatever you want.
Yeah.
But generally it's a junior, and the seconds are people who are not the direct.
I think that's the grandfather or something like that.
Like grandfather or an uncle. Well, it makes you unique.
He's from West Virginia and didn't like a bunch of juniors.
That makes sense.
Well, West Virginia is still in the United States, right? Yeah. Okay. Well, they're still, they can be unique and different. You are charged with, as you probably are intimately familiar with, in 26 CR 485, the 3rd-degree felony of fraudulent use or possession of identifying information, IDs of some sort. And that is a 3rd-degree felony according to this, but also the grand jury alleged in paragraph 2 that you have a prior burglary of a habitation conviction out of this court in January of 2020. So if all of this was found true beyond a reasonable doubt, that 3rd-degree felony becomes a 2nd-degree felony punishment. Do you understand how that works?
Yes.
It gets enhanced. And in 26 CR 486, you're charged with a 2nd-degree felony of aggravated assault with a deadly weapon. And they allege 2 different methods that the crime was committed, and also that burglary of a habitation prior conviction in 2020 is included in the indictment. So that 2nd-degree felony, if all of this is true, it would be punished as a 1st-degree felony if you're found guilty of all of that. And so you're looking at up to life in prison on that case. In 26887, you're charged with the 3rd-degree felony of evading arrest or detention and the burglary of a habitation prior conviction out of this court is included as paragraph 2. So if all of that true, this conviction would be a 3rd-degree felony punished as though it were a 2nd-degree felony. So that's 2 2nd-degree felonies and a first in punishment. And finally, in 26 CR 1162, you're charged with attempt to commit theft of property, a 3rd-degree felony. If convicted, that's up to 10 years in prison. But paragraph 2 is the burglary of a habitation that's been added again. And if that's true, that is a 2nd-degree felony. So in punishment. So you were looking at 60, on all of this, 16 years confinement in prison plus life imprisonment added to that as a potential punishment in each of these 4 cases. And you are not eligible for probation in front of a jury, you understand, because of a prior conviction, if true. What are we doing today?
We have a little more time, Your Honor. I'd like to talk to Ms. Moore a little more about the case. I think we can come to a resolution.
How much time do you need?
About 4 weeks.
Okay.
Yeah, it's kind of a new case, Your Honor, compared to the other ones we have.
Okay. 4 weeks. All right, we started 4 weeks. And you'll talk to him and make.
Yeah. I'm talking a little bit. He's
He seems like a smart guy.
He is. At least one.
He needs to know all that you know.
I know.
Okay. All right. We'll reset 4 weeks. Thank you. Let's say again. Okay, thanks. Chambliss, Christopher Chambliss.
So Your Honor.
2 cases.
They're all invested.
I guess you have those Chambliss.
Yeah. And I need,
What do you think?
y'all have been paid.
And we go on violation. It's just one of the technical sides for it.
Yeah. You think it's whatever you.
Yeah.
Number 1.
So if you got,
Yes, fine.
I think you get it right in front. In front, it's like the flower down the box. You get it one more time, you the darker than that, it's right outside the box.
Those ones, that is for my wages of conviction, should be polished.
We'll do number 1, especially in this one.
All right, there are 2 cases here called 24 CR 747, which appears to be a first amended motion to revoke probation, and then 26 CR 611, assault on a public servant in 747 is a 3rd-degree felony, and 26 CR 611 is another 3rd-degree felony, a new case. Oh, okay, so he's placed on probation for assault on a public servant in 2024. Okay. So the deal is what here?
2 years, Your Honor, on the revocation to run concurrent with 2 years. And if I may elaborate, Judge, the defendant is taking early responsibility for this case. He is accepting responsibility rather than reset after reset. And I would point out that in the new law violation, Judge, he, as far as assaults go, I mean, it's not the most egregious assault. The allegation is that he punched a correctional officer and bit another, during which he was allegedly having a medical episode of some sort, possibly a seizure. And lastly, Judge, there have been some mental health, history of mental health issues with this defendant, which, while not exonerating, could very well be.
Again, that last part again?
There has been a history of some mental health issues.
The other part.
While not exonerating, Your Honor, it very well may be mitigating. So that's how the state arrived at its offer, Judge.
I would reiterate everything there. This is a situation where we've had Mr. Chambliss in and out. We've had revocations before. We continue him on probation. We try to get him help. At this point, it's best to sentence him to prison and be done. And I think based on all the facts and circumstances, the 2 years is adequate for the facts of the case and all the things leading up, like Mr. Coleman just said. And this is one of the few times you'll get Mr. B and Mr. Coleman completely agreeing on something.
Look, I don't see anything from the victims here in the file. I want to know what their position is. We have our job to do in the jail. And his consistency on harming jail personnel doesn't impress me one bit. You were pleaded guilty back in March, and you were placed on probation in that case. But in the first case, you were convicted in September of 23rd, placed on probation and for assault on a public servant, sentenced to 10 years in prison, probated for 10. And apparently, I mean, that's the most you could get. Apparently, the DA's office thought that was serious there. And then, so you assault the public servants on 2 occasions. Assault what we're saying, and as the probation office wrote, in its findings, he was granted 10 years probation on September 3rd, 2024 for assault on a public servant. Alarmingly, just 2 days later, on September 25th, he reoffended by committing another assault on it's not that. I'm sorry. It's been a servant at Baptist Hospital. Now, that's not what's represented in the new indictment on 26 or 611.
Take a semester off, get you another 889. You can get as much as you done against for very little.
What happened on the September 25th incident in 2024?
I don't know, Judge. I don't have sufficient information to speak to that.
On 9/23, and 2 days later, commits another assault at Baptist Hospital. But that's not what this indictment is. So we've had a third assault.
Your Honor, I believe, I'm looking at online here, that I think that was dismissed as part of,
Nonetheless, we're talking about 3 assaults allegedly occurring.
Yes, it was dismissed.
One he's pleaded guilty to and was on probation for, and then a second occurred 2 days after he was placed on probation, and a third occurs here in this new indictment.
Sure. Yes.
And so as the probation office states, while in custody, the defendant has continued to exhibit a persistent and dangerous pattern of behavior that shows a complete lack of concern for the health, safety, and well-being of others. Most recently, on about March 6th, the defendant committed yet another new offense. This repeated criminal conduct strongly indicates a profound lack of remorse for his prior offenses and a callous indifference to the harm inflicted to his victims. It's evident he poses a significant and ongoing risk of reoffending, particularly against public servants. What about that, everybody? Y'all are asking for the men to run concurrently?
I think, Judge, from the state's perspective, I think we'd be hard pressed to get a jury to give some significant.
No, but it won't be hard for us to get a motion to revoke probation. That's what we're going to do.
Yes, sir.
I'm not taking that deal. We'll hold a hearing and I'll make the decision.
All right. Yes, sir, Your Honor.
As soon as possible. Thank you. Sherelle Management.
Hopefully everything else I got is hopefully down to something.
Who's Manuel?
You just come back in January. I usually go once every other year, but this time they asked me to go. So
you should go like this.
No, January. Yes, yeah. I always go in August, but not in January this year. So
okay,
I'm going in August.
Oh, okay. Gotcha. Here.
Manual? Yeah. Come on over. Does this lady need to go in front of anybody?
Yes.
Please come forward in front of that lady. Thank you, ma'am. Thank you very much.
You should not say town.
It's hard to walk in those things.
And then you're going.
Yeah. Yes.
Century over, you could have the guys that made or a little bit I
need to be quiet somewhere when you've got that.
That's not that way good. Because there was no quiet place in the hotel. Almost dead. You go. Yeah. The school started. Yeah. She's supposed to sleep. I love it. This way. She says, let's just, let's not go. It was one of the kids acted fun. Like tonight, he just was great.
Hello. You are Sherelle Ann Manuel?
Yes, sir.
And you're here with Mr. West, your attorney and the state's attorney. There is an indictment that's been handed up, ma'am, as you probably know, 26 CR 61. And does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir, please.
In summary, ma'am, this states that on or about November 19th, 2025, in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. It states, let's see, by kicking Troy Owens in the leg with your foot, and you knew that the complainant was a peace officer who was lawfully discharging a duty, namely arresting you. Apparently, he was a peace officer. Let's see.
Beaumont Police Department.
Is Beaumont Police Department. Do you understand what you're charged with here?
No, because I never keep any money. I never keep any money.
Okay, well, the grand jury says you did, and I'm sorry. What do you want to do?
No, I'm going ahead and going with him.
You want to plead guilty today?
No.
You're going to have to admit this, right? Okay, is that what you're going to do? Now, and what is the deal?
No, it's deferred.
Deferred probation?
It's deferred.
Okay. But you have to admit you did it, you know? I can't put you on probation if you didn't accept responsibility. Are you going to do that? All right. This is a second-degree felony, which means if convicted, you face a term of not more than 20 years in prison or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what the worst scenario is here?
Yes.
An agreement has been reached where you would be pleading guilty, not found guilty. You would be placed on probation and you would not go to prison as long as you followed the terms and conditions of probation, and you would be fined $500 among other terms and conditions of probation. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, this second-degree felony of assault on a peace officer? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Guilty.
I'm going to show you what's marked as State's Exhibit 1 after Mr. Laird signs it. Thank you. Did you sign that? Understand it? Discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 is tendered into evidence. Without objection, it's submitted. Among other things, and by the way, before I'm about to say what I'm about to say, the court requested Dr. Ed Grapon, licensed psychiatrist, to evaluate the defendant as to competency, and in a report dated June 26, 2026, Dr. Grapon, in his analysis, determined that the defendant is competent to proceed to a resolution of her legal issues, and she demonstrated no evidence of psychosis, and her thought process appeared to be free of auditory or visual hallucinations, illusions, or delusions. She is currently on psychoactive medication and appears to be responding well to that treatment. Keep taking your medication. That's important.
Yes, ma'am.
And, she is responding well to medication management and is not in need of psychiatric involuntary inpatient treatment intervention. And she should continue to do well so long as she continues to comply with the appropriate medication.
Okay.
That's important. That's going to be required of you. Yeah. All right. Court's Exhibit 1 is made a part of the record for all purposes. The analysis by Dr. Ed Grapon finding the defendant competent. And I find that the defendant is mentally competent to enter her guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting her guilty plea from State's Exhibit 1 admitted here to find her guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place the defendant on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation. Make sure you follow them. You follow them and you stay a free lady.
I'm going to Houston.
Yeah.
I have an apartment in Houston.
Yeah, we're going to let you, you're going to work with the probation officer, and we're going to work on allowing you as much freedom as you can to live as long as it's in the United States and in the state of Texas. And there will be, we'll try to get courtesy supervision with another agency so that you can report to Houston rather than coming to Beaumont. You will be placed on a mental case health load to make sure that you take your medicine properly and you stay competent, and you will complete an anger management program, among other conditions of probation. And again, this is for 10 years. You do well, I will shorten it to 3 1/3 years of probation. Yes. What's your criminal history, if any?
She has a couple of just family violence and theft.
No felonies?
And no felonies.
Yeah, you don't, this is a felony. You don't want a felony conviction.
No.
And so you were not convicted here. We placed you on probation. So follow your terms and probation that this man is going to go over with you, and you will stay clear of prison and take your medicine regularly.
Yes.
And remember, don't, always be composed as best you can. Sometimes everybody loses their composure and gets upset, or their temper takes over. Be careful. You have a lot to lose if you let your temper get in the way.
Yes.
More than all of us, because you're on probation, and it can be a violation of probation. So live honestly and don't harm anybody. Give everybody respect, and they will give it to you.
Yes, sir.
So thank you, ma'am. Please see the probation officer. Thank you.
Wow. That's right. Right here. I'll put it on our misdemeanors to her.
Let me see that. God bless you. God bless you. It's still big. Derek, pipes.
Wait, also on. We're saying he's invested as well.
I need Derek Pipes, please.
You know exactly something. As long as it rains, it's well. You can see this house is big.
Let's clear out pipes.
Trying to.
Do you have pipes? This wasn't what I was thinking. Just want to make sure that you wrapped your pipes. Oh, there he is. We're doing, please, right, John? He's going to come over to this lady. Sir, you're Mr. Pipes?
Yes, sir.
Derek? Oh, lady right here.
It's a revocation, so you don't. The revocation.
You have his thumbprint
Yeah.
and nothing but his thumbprint. So help you God. We have two cases here, 23 CR 617 and 618. State Attorney, does the defendant waive a formal reading of these motions to revoke unadjudicated probation in each case? Can we proceed in summary?
Yes, Your Honor, please.
Sir, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Lower your hand. In summary, sir, these motions similarly allege that on August 14th, 2023, in this criminal district court of Jefferson County, Texas, you were placed on deferred or unadjudicated probation for 10 years for two cases. One of them, the second-degree felony of assault on a peace officer in 23 CR 617, and that's a second-degree felony. And the other case was a third-degree felony of obstruction or retaliation in cause number 23 CR 618. Are those allegations true and correct, sir?
Yes, sir.
All right. What are we doing?
Which one did you get time on in Chambers, Ken?
Which
Which one did you get time on in Chambers, Ken?
Obstruction.
Just plead to 2 and 3. Those are the obstructions over in Chambers County that you got time on.
Allegation number 2 in each of these motions state that you committed the offense of obstruction or retaliation on or about March 31st, 2024 in Chambers County, Texas, which is a violation of condition 1 of your deferred or unadjudicated probation order, which states don't commit another crime. Are the allegations in each, similarly in each of these 2 motions, true and correct? Allegation 2.
Yes, sir. That's good enough, Judge, since he's already agreed to it.
Are you pleading true and correct to these allegations, similarly committing the offense of obstruction or retaliation voluntarily and because those allegations are true as they are alleged?
Yes, sir.
Do you understand that voluntarily and knowingly made plea of true to 1 or more violations of probation, such as these criminal charges that you're pleading true to, that is enough to grant a motion to revoke probation, as in each of these 2 cases? By a preponderance of the evidence or greater, your probations can be revoked and you can be sentenced in this second-degree felony in 23 CR 617 to no less than 2 nor more than 20 years confinement in prison. And in this third-degree felony, 23 CR 618, the obstruction case, no less, you can be sentenced to no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true to these allegations today?
Yes, sir.
Fine. You were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes.
And this. See how this story ends. 4 years on each case?
Yes, sir.
Yes.
Is that it?
Yeah.
So in each of the plan is you would be pleading true, your probations would be revoked, you would be found guilty, sentenced to 4 years imprisonment on each of these cases to run concurrently. Is that your understanding of the plan?
Yes, sir.
If I follow these agreements, and that's in each case, if I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
I'll show you what's marked as States Exhibit 1. Did you sign those documents, understand them, discuss them with your attorney?
Yes.
Are the contents all true and correct?
Yes, sir.
States Exhibit 1 is tendered into evidence in
No
each case
objection.
without objection admitted. And this states that you are making your decision voluntarily, knowingly, intelligently. You've discussed this with your attorney. You are mentally competent to enter your pleas of truth. And all of this is voluntarily and knowingly made by you because these allegations are true.
Yes, Your Honor.
States Exhibit 1 is part of the record for all purposes. I'm going to follow these agreements then. I'm going to find in each of these motions to revoke unadjudicated probation, again, cause numbers 23 CR 617 and 618, you have pleaded true to allegations 2, which is committing the offense of obstruction or retaliation on or about March 31st, 2024 in Chambers County, Texas, which is a violation of condition 1 of your deferred or unadjudicated probation orders, which states don't commit another crime. You have you are admitting to these violations voluntarily, knowingly, intelligently. That is enough to grant these motions to revoke unadjudicated probation. And I grant this motion by a preponderance of the evidence or greater in each of these cases. Thus, your deferred or unadjudicated probations in each case are hereby revoked. In each of these cases, you entered your guilty pleas before this court when you were placed on probation on or about August 14th, 2023. You entered your guilty pleas in each of these two cases voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from States Exhibit 1 admitted at the time of your plea hearings to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. That is the second degree felony of assault on a peace officer in cause number 23617 and obstruction or retaliation, a third degree felony in 23 CR 618. Being found guilty beyond a reasonable doubt in each of these two cases, I'm going to follow these agreements made by the parties. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years imprisonment on each case. Sentences shall run concurrently. Do you understand what's happened today?
Yes, sir.
You will be given credit for all time you have served in accordance with these cases. Anything else? State and defense. Okay, good luck.
Thank you.
All right, my friend. Please.
Thanks.
All right, I think we did a good thing wrapping up those pipes on those two cases. And is there anything else we needed to do on that?
No, sir.
Okay. And you are?
Sandoval. It's the next one.
Sandoval. Okay. I snuck up on it. I was just getting stealth-like. That lady. Here we go.
Can't stop of it. But actually, ma'am, can you step it over here? Oh, yeah, over here. That's a
Amanda Kane.
Yes. The involved hand, she's one organ, so those are one group, and I can make yourself a dog. Yeah. You don't feel right front.
No, I had to put. We give a discount on the tickets. Okay. And we pay about $3,000.
Flowers here don't always.
To fly there and to have other than body, which really isn't much of an hour. And then this time, express close up with a 1-day safari.
We'll get a lot of assaults on a peace officer today. Well, I guess it's
when you not legalized closure.
okay. Do you have Sandoval's about 5 million? So how many others do you have over there? Oh, good. Just suspicion. You get tired. All right, 26 CR 455 is now called the state of Texas versus Amanda K. Sandoval. That is you. With Mr. West, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment? Here, can we proceed?
Yes, sir, please.
In summary, ma'am, this indictment alleges, as you probably are intimately familiar with, on or about February 23rd, 2026 in Jefferson County, Texas, you committed the third degree felony of assault on a public servant. Do you understand what you're charged with? Yeah. They said, he can't stop. That was just, I didn't let that This is a second degree felony. If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement has been reached in your case where you would be pleading guilty but not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length. There would be terms and conditions of probation which are normal and customary for this type of offense you must follow. And that keeps you on deferred or unadjudicated probation, keeps you from getting found guilty. If you failed while on probation and committed violations of your probation could be revoked. You could be found guilty. And this is Amanda Sandoval.
Yes.
The indictment says third degree felony. This has been checked second.
Oh, I may have checked the wrong one there.
That's my sorry. You're looking at no less than 2, no more than 10 years confinement in prison. And 10 or 20, there's nothing good about either of those, but one's more than the other. The correct is this is a 3rd-degree felony, so it carries with it no less than 2, no more than 10 years confinement in prison. And the fine to $10,000 can be assigned. The racer. God, I hate this thing. It's stylus. I don't know who did it, but I think it was done just to aggravate us all. I don't want to just turn the thing to do. The end was the racer. And then you went with me. You say I had to put a pad over it because of the way I like left-handers. You know, we always had an arm over the paper. All right, this is a 3rd-degree felony. No less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. The agreement is you would be placed on deferred or unadjudicated probation, which can be up to 10 years in length, and fined $500. You do well. Probation can be ended and concluded in 1/3, 3 1/3 years if you do well. Is this your understanding of the plan? If I follow this agreement, you have no right of appeal. How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? And because you are guilty? That's yes or no?
Yes.
Okay. I show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 is tendered into evidence. No objection. Without objection, it's submitted. Among other things, ma'am, this states that you sign that you are mentally competent to enter your guilty plea. It's freely, voluntarily made. You know what you've been charged with. When it's been read to you, you read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true of state, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived. Yes, please. I am going to follow this agreement. I'm going to find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence from State's Exhibit 1 admitted here that you signed to find you guilty beyond a reasonable doubt. But I'm not going to do that. So long as you follow the terms and conditions of probation, you will be on a deferred or unadjudicated probation, not found guilty. Make sure you do. If you fail, your probation can be revoked. You could then be found guilty and sentenced, in this case, up to 10 years in prison. You don't want that. Among other conditions of probation will be to complete an anger management program, and you're fined $500. Anger management, that's a good thing for almost everybody. Sometimes you lose composure. When you lose composure, you do things you wish you wouldn't have done, and you get punished for it. Like in this case, fix this and you'll do better. Just when you feel upset, you got to call a timeout in your own mind and count to 10 or whatever it takes to focus. You'll get over it quick enough and you won't be looking at criminal trouble. And that's a good thing for everybody, as everybody gets upset. It's how you deal with it, though, is the way that keeps you out of trouble. Okay. Please see him and good luck on probation. Thank you. Let me see that last one again. Thank you. Okay. Next, I've got. What do you do?
We're gonna try to roll again.
Yeah.
Say it again.
Right, guys.
Yeah.
Mr. Wall, please.
You didn't want the first, we're gonna try to.
Well,
Running it.
Damien. Slap that thing on there hard. Yeah, you're mad.
Getting revoked on this.
Okay, I can do it.
Yes,
I can do it.
We're changing it to within 2 years, 24 months, Judge.
Hold on, is it 2 years or 24 months? Well, y'all think about it.
Not 24 years.
Not 24 years.
We're back.
So.
Mr. Walls is here. Hold on, the pad is not here yet. There, it's struggling. Yeah. Oh, here we go. Okay, so what are we doing
24 months state jail.
on each one?
Yes, sir.
Nobody changed this one. It says 15 months.
We didn't go back and get them on and change them on either of the cases, Judge.
This is the one that you rejected earlier where it's changed from 15 to 24 because the court wouldn't take the 15.
So we're just asking the court to change it from 15 to 24 months.
Okay. And I just put 2 years.
Yes, sir.
Because
That's what I would mean. That's why I said 2 years.
what happens is sometimes when they're up there, when they're doing the paperwork, they see 24 and they think it's years, not months. And you don't want that. You want so let's make it easy for the bookkeeping up there and the bookkeeping in the sky there. 2 years. And okay, so they can't make a mistake unless they give you 2 months.
They'll take that too.
All right, once again, in each of these cases, 24 CR 2228 and 24 CR 2343, the state of Texas versus Damian Walls. The court recognizes Mr. Walls, who is present with Mr. Turkle, his attorney and the state's attorney in the probation office. And again, we'll start from the beginning here. In each of these first amended motions to revoke probation filed on May 1st of this year, does the defendant waive formal readings of these? Can we proceed in summary?
Yes, Judge.
And we'll take them up together since he is placed on probation for thefts, similar offenses, and he was placed on probation on the same date, and he was assessed the same punishment. On each of these cases, on October 14th, 2025, this alleges that you, Damian Walls, was sentenced to 2 years in the state jail, suspended and probated for 5 years in each of these cases for state jail felonies of thefts. Are those allegations all true and correct? Yes. And number one states, allegation one states you failed to report to the probation office as directed on or about November 25th, November 27th. I'm sorry, November 25th, 2025, January 27th, March 6th, and March 6th, 2026. 3 different dates you failed to report. And that was required of you. You failed. That was a violation of condition 4 of your probation order to report regularly. Are those allegations true and correct in each case? Are you pleading true and correct to that voluntarily? And again, because you are true, they are true. And I earlier placed you under oath. You were still under oath for purposes of this hearing. All right. That is enough, voluntarily and knowingly made plea of truth is enough to grant a motion to revoke probation by a preponderance of the evidence. Your probation can be revoked and you can be sentenced to no less than 180 days up to 2 years on the state jail in each case. Knowing that, you insist on pleading true today.
Yes.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Agreements have been reached where your probation would be revoked. You would be sentenced to 2 years in the state jail on each of these cases. Is that true?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes.
And there is still is there restitution on each of these?
Just one.
Which case?
2, 3, 4, 3.
Okay, the court is going to make a finding. I'm going to follow these agreements, and also the judgment will reflect that restitution is nonetheless owed, and somebody might be able to file a lawsuit later and get the money from you unless you pay this. But these sentences I'm going to follow these agreements and sentence you to 2 years in the state jail on each case. But on 2, 3, 4, 3, there will be a finding in the judgment that the defendant owes a restitution to the victim in the amount of how much?
$3,130.59.
I'm going to follow these agreements. Anything else to add? All right. Then you are pleading true voluntarily, and because these are true, these allegations are true in each case, correct, sir? You have to speak out so she can.
Yes.
Okay. With nothing further from the parties, I'm going to find that there is sufficient evidence supporting these first amended motions to revoke probation to grant them by a preponderance of the evidence or greater, as allegation 1, failing to report as required, was failed in each of these cases by the defendant. And he admits that his probations are hereby revoked in each case. Earlier in these cases, the defendant had pleaded guilty voluntarily, and he was mentally competent to do so. He understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt, which is what we did on or about October 14th, 2025 in each case, but we placed you on probation. You were sentenced to 2 years in the state jail, probated for 5 years. Your probations are hereby revoked, and you were sentenced to confinement in the state jail division of the Texas Department of Criminal Justice for a term of 2 years on each of these 2 cases to run concurrently in 2, 3, 4, 3. The judgment will also reflect that restitution in the amount of $3,130.59 is owed and is payable to the victim, in that case, Sean Atkins. And I'm sure these dotted the I's.
Judge, if I might clarify, I want to make sure that
go ahead.
It's payable to Sean Atkins as a representative of Howe Furniture, not personally.
Yeah, just his name is the only.
No, sir. I just want to make sure that way he can't personally come and sue my client for an additional amount.
Well, it's just I'm just saying what the indictment.
Yes, sir. I'm just clarifying for the record.
Is showing as he's the victim.
Yes, sir.
In a representative capacity or personally.
Not personally, just representative of Howe.
Well, I mean, the way it's written, it's in that way. It's either way, but he's not going to get doubled. You don't pay twice. The restitution is owed, period, in one sum. Anybody? Sure. That one's done. What it means is if you don't pay, they have good cause to file a lawsuit against you. And then that's never a good thing because it ties you up and it costs more money. You got to get a lawyer. It costs more money. It's better just to pay it if you can and you move on with your life. Not that lawyers aren't good people, but it's they're not for free. And there's good reasons because you don't want somebody who's not familiar with the law to be representing you. They didn't have this done. Okay, Mr. Wallace, we've got it all done. Thank you very much for bearing with us. That is all on that. Next is, who do we have? John, what do you have?
I have Mr. Altman from the trial.
Did Langston ever?
He's went down to San
Okay.
He's back.
I'm sorry, what did you say, John?
I said I have Mr. Altman from the trial this morning.
Yeah, what about him?
We signed the paper.
Oh, okay.
But let's get out.
The Alderman, you say?
Yes.
Okay. Do I have that filed? Yes, Jason. 2 cases, 3 cases, 4 cases.
One dismissed.
Okay. Okay. I like your style. It looks like one's going to be dismissed. He's pleading to 3.
Yes, sir.
Okay.
Raise your right hand. Swear or affirm to tell the truth, whole truth, and all the good advice you got. Yep. Get the right tongue press. Place it flat in the mouth. Put one more time, see. Put the part there.
1423 is to be dismissed. That's a statement.
No, she added more.
Okay, we call 4 cases, all filed the state of Texas versus Jason Charles Altman. That's you, sir?
Yes, sir.
With Mr. West, your attorney, and the state's attorney. And we've got cause numbers 24 CR 607, unlawful possession of a firearm by a felon. 24 CR 608, illegal possession of a controlled substance. 24 CR 2189, illegal possession of a controlled substance. And then there's a final one, an outlier, 24 CR 1423. Illegal possession of a controlled substance, and I believe that case is to be dismissed. So I'm going to put that one aside. Does the defendant waive on the other 3 cases formal readings of the indictments and the arraignments? Can we proceed in summary?
Yes, please.
In summary, 24 CR 607 alleges that on or about November 14th, 2023 in Jefferson County, Texas, you committed a 3rd-degree felony of unlawful possession of a firearm by a previously convicted felon. Do you understand what you are charged with in 607, sir?
Yes, sir.
You're facing a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable here?
Actually, it's enhanced up, I believe, to the 2nd degree range. Is the office 15.
That is accurate, Judge. This one starts out initially as a 3rd degree.
3rd, but it goes to second punishment range. So it should have been written down there. So.
Okay, I'm going to change this from a 3rd degree to a 2nd degree. Everybody's okay. All right, this is a 2nd degree felony, which, and also it's because there's a paragraph 2 goes on to allege that you were previously convicted in 2003 out of this criminal district court of Jefferson County, Texas for aggravated robbery. Is that true and correct?
Yes, sir.
Are you pleading true and correct to this voluntarily and because it is true as it is alleged? So Unlawful possession of a firearm by a felon. Paragraph 1 is normally a third-degree felony, but when you're pleading true to a prior felony conviction above a state jail, like aggravated robbery, a first-degree felony, that enhances the punishment range a degree to a second-degree felony. You are facing a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty, sentenced to 15 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
This will run concurrently with 2 other cases, and part of this agreement, 24 CR 2189, one of the 4 cases here will be dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Put that one aside for just a moment. Go to 24 CR 608. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor, please.
And then we're enhancing this one too, right?
Not on this one. It starts out as a second-degree, Judge.
Okay, in 24 CR 608, paragraph 1 alleges on or about November 14th, 2023 in Jefferson County, Texas, you committed a second-degree felony of illegal possession of a controlled substance, namely methamphetamine. Do you understand what you're charged with?
Yes, sir.
You are facing no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached in your case as well, as you would be pleading, in this case, that you would be pleading guilty, sentenced to 15 years to run concurrently with other cases. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will.
Yes, sir.
And because you are guilty.
Yes.
Here. And then go to the third one. 24 CR 169. No, I'm sorry. 24 CR 218. Again, does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in such?
Yes, Your Honor, please.
We're going to do an enhancement on this one. Right?
Yes, sir. I'm listening to you.
All right. In summary, paragraph 1 alleges that on or about May 10th, 2024 in Jefferson County, Texas, you committed the third-degree felony of illegal possession of methamphetamine, a controlled substance. Do you understand what you're charged with?
Yes, sir.
Paragraph 2 goes on to allege, though, that prior to the commission of that offense of illegal possession of methamphetamine, you were convicted in this criminal district court in 2003 for the first-degree felony of robbery. Is that all true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily, knowingly, intelligently, and because it is true?
Yes, sir.
Oh, so paragraph 1 and 2 constitute a state jail felony. You are looking if convicted at a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Judge, I think you stated state jail. It's actually a second degree.
So
I heard you say state jail, but it's actually a second degree. If I'm mistaken, I apologize for interrupting.
It's a second-degree felony, which carries with it no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? Not a state jail, but
Yes.
Prison. Institutional division of the Texas Department of Criminal Justice's institutional division. And again, a fine up to $10,000 can be assessed. The agreement is you would be pleading guilty, sentenced to 15 years in prison to run concurrently with the other 2 cases that you're going to be sentenced to 15 years in prison on. Is that your understanding?
Yes.
If I follow this agreement as well, you have no right of appeal of your case. Do you understand? How do you plead in all of this? In each of these 3 cases, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And again, these prior convictions alleged in 607 and 2189, are those allegations of prior convictions true and correct as they are allegedly aggravated robbery? And are you pleading true and correct to that voluntarily?
Yes.
And because it is true in those 2 cases?
Yes.
And in other words, you are looking at 2nd-degree felony punishments in each of these cases, no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 in each case. The plan is you will be sentenced similarly in each of these cases to confinement in prison for a term of 15 years to run concurrent. All right. If I follow these agreements again, you have no right of appeal.
Yes.
Anything else to add? I'm going to the findings.
The only other thing I want to add, Your Honor, just for the record, is that the state did file a motion to enhance all these cases. If we would have went to trial, it would have been a habitual and 25 to life resolved before we got up. So I just want to put that on the record.
Did you understand that, sir?
Yes.
Anything else?
Nothing.
I'm going to find that in each of these cases, 24 CR 607, 24 6R 608, and 24 CR 2105. The defendant, Jason Charles Altman, has pleaded guilty in each of these cases voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1, admitted to find you guilty beyond a reasonable doubt. And each of these cases are punished as second-degree felonies, as you have pleaded true to prior convictions in 24-607 and 24 CR 2189. And so you were looking at less than 2 no more than 20 years confinement in prison and a fine up to $10,000 in each of these cases. I'm following these agreements in each of these cases as agreed upon. You are hereby found guilty beyond a reasonable doubt of these second-degree felonies, and you are punished in each of these cases for confinement in the institutional division of the Texas Department of Criminal Justice, so a term of 15 years in prison. In each case, the sentences shall run concurrently. And finally, 24 CR 1423, that case shall be dismissed as part of this agreement. Do you understand what has happened today, sir?
Yes, sir.
Anything else to add by anybody?
Right.
If not, do your recess. Thank you.
I got all my back time, right?
You get credit for all time you have served in accordance with the case. I am signing 24 CR 1423 of dismissal. See that? Let's see. Maybe take those to go from this time. No. Right. No. Sorry. Do that now. That's it. Here you go. Thank you. I had the Corey Shiloh was a status hearing. Ryan Gertz was supposed to be here. Any word? Has anybody heard? What, Mr. Coleman, what was this going to be about? Do you know?
Just before the finish and they counted the murder, defendant we played last week.
And what we were going to do?
I don't know how the state's ready to proceed with. We've made an offer quite some time ago, and if a trial is needed, then
Did we hear from Mr. Gertz?
Judge, after that, it was.
I routinely do not hear from Mr. Gertz.
Well, put it on the trial docket. Let's see, that's done. I think Langston is up on Bolton Fault.
Oh, we ready, Judge. That's a M2RG. And we are ready.
Here's
We're gonna move it today.
hey, I have Leander Elam, by the way, on a side note.
That's already played. I signed him up.
Today?
Yes, that's
He's
done.
gonna be.
You signed him up? I didn't see him on chat.
No, Elam.
Oh, it's not.
No, that's not Elam. This is fault.
You're Mr. Colton Falk?
Yes, sir.
Does he need to go in front of you? It's a motion to revoke probation.
Yes, sir.
All right. 19-31683 is called. Uh-oh. I'm looking at first amended. And
First amendment.
first amended is right here.
I don't have a first amendment.
I don't have first amendment. That's news to me, you know? Because what I showed him was just the MTRP that I got, but I didn't get a first. This is the only one I got is this right here. Unless y'all did something new that I don't know about.
I've got one.
Hold on, everybody.
Got one.
Here's the problem.
Yes, sir.
Here's the problem.
The one I have is 5/7/26.
That's what I have.
Okay.
There's a new one. I don't know about that somehow.
There was a motion to revoke unadjudicated probation filed June 27th of 2025. He pleaded true to allegations 1, 2, 3, 4, and 6, as well as 8 in November of 2025. What happened on that? Did we just continue him on probation?
I think what happened, Judge, you put him in a JCDI program.
Did we continued him on probation?
Yeah. And the completion of that is one of the violations of this one.
Okay. And so we took care of that. Now there's a motion, and this says first amended on it, but I think we disposed of that first motion, right?
Okay, so maybe.
So this new one is going to be another motion with 4 new violations.
That is correct.
Okay, so yeah, we're starting from scratch again. It's another motion to revoke probation. And this was filed on May 7th of this year. So June, July, almost 3 months ago. And you are Colton Chase Falk.
Yes, sir.
Raise your right hand, sir. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Lower your hand. You were here with Mr. Adams, your attorney, the state's attorney, and the probation office is here. Does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes, sir.
In summary, sir, this motion to revoke unadjudicated probation, again filed May 7th, 2026. It alleges that on February 10th, 2020, in this criminal district court, you were placed on 10 years deferred or unadjudicated probation for the first-degree felony of robbery. Actually, it's aggravated robbery. That's what makes it first degree, not second-degree felony of aggravated. I'm going to amend this. Anybody object?
No objection from the state judge.
Oh, I'm adding aggravated when he was properly placed on probation for. Any objection?
No, sir.
Corrected this thing. Is that true? All right. Allegation 1 states You failed to submit to alcohol and or drug screening on or about March 21st, 24th, March 23rd, 31, April 9th, April 5th. Okay. This is on or about March 21st, 2026, March 21st, 2026, March 24th, 2026, March 31st, 2026, April 9th, 2026. Then it shows April 13th, 2023. Are you kidding? We going back 3 years? Or is that wrong? Or is that a mistake? Is it?
Judge, that very well may be a typo, and we would abandon that particular allegation, Judge.
In April 21st of 2026, you failed to submit to alcohol and or drug screening at the direction of the probation office. That's a violation of condition 27 of your deferred or unadjudicated probation order, which states submit to alcohol and or drug screening at the direction of the probation office. Is that allegation true?
That's correct.
Are you pleading true to this voluntarily and because it is true as it is alleged?
It is 100% true.
You understand that knowingly and voluntarily made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation. Your probation can be revoked. You can now be found guilty and sentenced in this first degree felony of aggravated robbery to no less than 5, no more than 99 years confinement in prison or life in prison. Knowing that, you insist on pleading true today.
It's true.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. I'm going to skip 2, 3 states. You failed to successfully complete the Jefferson County Drug Intervention Program, JCDI, and comply with its rules in violation of a special amendment filed on November 12, 2025. Is that true or untrue?
It is true.
And number 4, you failed to provide verification of entering and successfully completing the anger management program as directed by the probation office in violation of a second amendment filed on November 12, 2025 to your probation order. Is that also true?
Yes, sir. That's true.
So again, are you pleading true then to allegations 1, 3, and 4 of this motion to revoke unadjudicated probation filed May 7th, 2026? You're doing this voluntarily, knowingly, intelligently, and because it is true as it is alleged in each of these 3 violations.
It's true.
We understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation. That's all it takes to grant a motion to revoke probation. And in your case, your probation could be revoked. You can now be found guilty of this first degree felony and punished no less than 5, no more than 99 years confinement in prison or life imprisonment. Knowing that, do you insist on pleading true today?
It's true, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Is there an agreement?
No.
All right.
And the reason why, Judge, the state.
What do you want to do?
I was going to take it.
Go ahead. Go ahead. You can go first, Mr. Hammond.
Thank you, Honor. The state had made an offer of 5 years, which you just explained to them, 5 to 99 is the minimum. Right. Right. And the reason why we decided not to take the 5-year offer that the state made is that
my credit for.
I'm sorry. The reason that we did not take the 5-year offer and what we're doing is we're going unagreed to you, and he understands the risk. I explained to him the risk of going unagreed to you. However, by going unagreed to you, he does have an opportunity to at least complete the JCDI program if you allow him to. And I do understand that this is a deferred adjudication, so the court could move this from a deferred and go straight to regular probation, possibly. But here's what.
How can I do that? He's charged with aggravated.
That's true.
What?
You're right. Yeah, it's straight probation. It's not possible
right.
under the law.
You're correct. But specifically, though, you could allow him to continue to be on probation. And what there are several accomplishments that he's had while he has been on probation. And I know that you take these technical violations seriously. He doesn't have any new criminal offenses. All of these are tech violations. And Judge, what I wanted to give my client an opportunity to do is I know that the state and Mr. Coleman had did offer a minimum, which is 5 years, but he wants to continue to remain on probation. So I was going to ask the judge to at least to consider some of the things that he had to say about that, because he's accepted responsibility. He's played true to the allegations that you asked him about. So it's not like he's denying anything. The only real question is that will you allow him to stay on probation and not violate him? And I
I'm not going to violate anybody.
Well, no.
I'll guarantee that.
but you
I want to make that clear.
Right. But you see what I'm talking about.
He would be violating the program, not me.
Correct.
And that would be a finding I would make. But I want to just get something straight with you. You said he hadn't committed any new criminal violations back in. He earlier pleaded true of committing criminal mischief on February 5th, 2025 in Orange County, Texas. Criminal mischief on February 6th, 2025 in Orange County. Committing the offense of assault, family violence, March 29th, 2025 in Orange County, Texas. Provided a urine sample that tested the presence of cocaine and amphetamines on May 6, 2025. Technically, that's illegal possession of a controlled substance. Those are 4 violations of the law that he pleaded true to in he pleaded true in this motion to revoke probation filed a little over a year ago on 6/27/2025. And for some reason, and then he failed to report all the numerous times on that. So, man,
I guess
what we did was like we ended up amending his terms of probation, I guess.
Yes, at that time, I believe you continued him.
I held the MTRP, but he admitted to 3 or 4 violations of 4 violations of law at that time. So he's not pristine on.
No. I guess let me more specifically clarify what I was saying. On this MTRP, there's no allegations of a new.
I understand.
Well, so that's what I really meant. But Judge, I guess what we hear is that, yes, I understand that the state offered the 5 years. He's asking you to continue. That's why we unagreed. So what I want to do is call him. It's not like he's not accepting responsibility. He's accepting responsibility for everything. So with that being said, is he and myself wanting to convince you to allow him to stay on probation and let me have you state your name for the record real quick.
Colby Falk.
All right.
And you're still under then we put you under the beginning.
Okay.
Okay.
So, Mr. Falk, you understand that the state had offered you 5 years on this, right?
Yes, sir.
And you said no to that, right?
Yes, sir.
And you wanted an opportunity to talk to Judge Stevens about continuing you on probation. Is that right?
Yes, sir.
So, in talking to him about continuing you on probation, let's talk about some of the highlights why you've been on probation, because that might be a reason to keep you on probation. We talk about good things, right?
Yes, sir.
Okay. One of the good things why you were on probation is that you completed the safety program, totally completed it. Is that right?
Yes, sir.
And just so we're clear, what's the safety program? I'm sorry.
In 21, I believe in August.
Okay.
Go ahead.
All right. So positive since you've been on probation, and just so the record is clear, safety program is what? What is that program?
It's a substance and municipality punishment.
Right. And you completed it in full, right?
Yes.
All right. Another positive why.
When was that?
I think he said 21.
Yes, sir.
All right.
Hold on. Well, we're going to go on that. That's great and fine, except subsequent to that, you pleaded true to having possession of cocaine and amphetamines in your urine on or about May 6th of 2025, which was a violation of your probation subsequent to that program.
Yes.
So that program wasn't foolproof.
No.
It didn't keep you from falling back and making a mistake in using drugs again, right?
Yes, sir.
And we're not going to go into the ugly side of this, but we could of where is your cocaine coming from and the methamphetamine, unless you're making it yourself, which is another crime. So, we put you through that program that was successful, but how many chances do you get? We put you on probation. When we put you on probation, that was your second chance. You committed these violations, 1, 2, 3, 4 crimes.
Next week.
And I gave you a third chance.
Let's not wait. Let's do it.
And you're asking for a fourth.
Right. And here's the second major accomplishment you had while you was on Judge Stevens' probation is didn't you complete your GED?
I did that as a cell unit safety.
I'm sorry?
When I was in a cell unit, I obtained my GED.
That's important.
You got a GED.
Because education makes you wiser.
Well,
If you want to make that decision. Some people know the options and they still choose the bad option. Education makes you wiser. It won't tell you what to do. It'll tell you what's the better choice and the worst choice. Then it's still free will on your part.
Yes, sir.
Okay, go ahead.
And then the next thing is that if we look at the date that you were placed on probation, I see it was February the 10th of 2020. You see that date right there?
Yes.
And then today's date, I believe, is August the 8th of 2026. So we're talking about a 6-year period, right?
Yes.
All right. Now, to my understanding, when I met with you, when you initially had your prior hearings before Judge Stevens, one of the things that came out was, and I wasn't your lawyer then, but one of the things that came out was your children, right?
Yes.
And
Say that again?
his children. He has 2 boys, right?
Yes.
And while you had those 2 boys before Judge Stevens, to my understanding, I wasn't there, but I mean, Judge was there, but to my understanding, another accomplishment of yours while you were on probation was you went and got custody of your kids. Can you tell me that?
Yes, it was ordered by him.
All right. And can you explain, because we're trying to get the judge to keep you on probation, right?
Yes.
So in keeping you on probation, judge basically saying, hey, you need to do something about these kids. And then in response to Judge Stevens, what do you do? Just tell me what you do in your own words.
Well, whenever I got out of safety, I was here for a 6-month status update, and you were made aware that I have kids and that I didn't have custody of them. And you said you wanted to see me back. I think it was 3 months. It could have been 6, but you wanted me to have custody of my kids along with a few other things that I needed to take care of, including catching fees up and stuff.
It's a parent's obligation.
Yes, sir.
Some don't follow through with it like they should. But yeah, I've always felt like you were capable.
Right. So as a positive to ask Judge.
When did you get the custody of the children?
A couple months after you told me, maybe not even that.
What's the date about?
I believe it was the end of 22, probably, maybe the early 23.
So the bottom line. Right. So the bottom.
Hold on. That's great. Except subsequent to that, you commit criminal mischief, 2 criminal mischiefs, and an assault, family violence, as well as possession of cocaine after you had the kids. What are you trying to tell me? What's good about it? You're putting children into an environment that's terrible. Look, you're showing me, look, here's my hand.
Mm-hmm.
Do you see my hand?
Yes, sir.
Do you?
Yes, sir.
Or now do you see my hand? Just don't show me one side. I've got to see both sides.
Yes.
Great getting the kids, but thereafter you commit 4 crime violations on my probation. Where's that good role modeling for the kids? I say great, wonderful. The kids need support and role modeling and good examples. And that's why I'm disappointed more than anything, because I felt you were capable of this better. That's why I'm just disappointed. I always, when I pitched in school, I wanted to pitch a no-hit shutout every time, a perfect game, and you don't. Hardly ever happens. But that's the way I am. I don't like failure. And I'm disappointed with this because I thought better. I had better feelings. But I don't know what you're trying to say. Getting kids is one thing, but you put them in an environment where you commit 4 crimes while you're on probation. Well, you're on probation for this serious crime of aggravated robbery, my God, which can take you to life in prison.
So basically, after the judge told you to make sure you're taking care of your kids, and then you get custody of your kids, could you tell the judge basically how those kids been doing in this 6-year period?
My kids are great. They're actually, my mom, since I was arrested, she stepped up. She has them temporarily.
I know. And I'm sure she's a good role model.
She's done amazing for me.
I know, but you're the parent.
I know. It's not her responsibility at all. And they're doing great. I don't like that they bounce around so much between schools, but where they're at now, I like to keep them in that school for the remainder of their childhood. But the stuff that had gone on whenever those new violations came about, I just went through a bad divorce, and it's an excuse. I'm aware of that, but
not everybody, but it happens every day.
I just messed up. So
marriages don't work, but why would you run out and get cocaine and methamphetamine? Criminal mischief, you must have thrown something around. It's not good.
Right.
But the kids don't have to be in an environment where y'all are hostile if it's because of that with your spouse, their mother. I mean, that doesn't look good. But but you're throwing in cocaine and amphetamine here in this.
And then, Judge, I know you said that the kids, in spite of those regressions, have been doing well. I know your mom is going to testify for you as a character witness, and I'm not going to be long. But when we get to the allegations that you pled true to, like the alcohol, the JCDI program, and verification of community service, the big accomplishment of yours, I think the judge told you while you're on probation, you need to do this. The biggest accomplishment is steady employment, right?
Yes.
And can you tell us about your steady employment and how that kind of interfered with you being able to do some of these things? In your own words, tell them whatever you want to say. Go ahead.
Well, I've been employed ever since I completed Safe P. I wasn't employed for I think it was 4 months I was here last year. And I did get behind on my fees there, but whenever I got out, I went to work right across the street from the jail at the Lindy Project. I was working there up until this till the motion was filed. Right about that time, I was going to change jobs, and once the motion came out, the MTRP came out, that kind of put a hold on things. But I mean, I've always had a good job, and really, to be honest, that job is probably it's not the reason. I mean, I'm the reason, but that job had a lot to do with me not taking that JCDI program and running with it. It was taking a lot of my time, and I didn't take the program serious enough. And I would like to go back to work to where I'm working a little bit less hours, and I could complete that program if given the opportunity to complete it. But regardless, I mean, that's one thing that I've always done and always will do is I will work. I will have a good job.
So with all that being said, I know the state had offered 5 years. We went to Judge,
which is the minimum, by the way.
It's right. We're asking Judge to continue you and keep you on probation, allow you to complete the JCDI program. And here's my last question before I call your mom, because I know she's a character witness for you. And that is, in your own words, tell Judge why you want to be continued on probation. You can tell them whatever you want to tell them. Go ahead.
I've thought high of myself since I was a kid. I thought I was destined for great things, and then it didn't happen like that. I've slipped, I've stumbled, and I've gone from being somebody that she wouldn't let in her house by herself to somebody that is called anytime anything needs to be done in her house. And to go from a drug addict to somebody that earns that right again is an amazing feeling. I'd like to get that back. I want to be proud of myself again.
Well, whose choice is that? It's your choice.
Yes, sir, it is.
Just make the right choice, which you're having problems doing. All of us are, everybody who's involved here is frustrated because we thought better of you. But again, you're saying the right things, but you go out and you still make the wrong choices. That's the problem. And all this event that the kids and work, that's fine. I worked since I was 16, 3 a.m. was my job, 80 cents an hour. Saturdays and Sundays making donuts. But it kept me out of trouble. Well, I don't know what the problem is with you. These are the wrong choices. And drugs again. There it is. And not going to drug screening when we were trying to help you. But it's just, you say the right things, but you have to walk the walk, not just talk the talk. You have to make the decisions. And we've been struggling here for several years on the decision making. Over 6.5 years, you've been on probation, and this is another motion to revoke probation, but it's crimes and failures to follow the rules that we all believe you're capable of doing, but we can't carry you across the finish line. You got to walk yourself. You got to make the trek like we all do by making right choices. And shame on you, really. You have all the good reasons for it. You got people who depend upon. That's what's so frustrating. But you come up here and say and then you admit I don't have any excuses for it, but you keep coming up to court. It's failing. When we all know you're capable of better, which just do it. But you have to pay a price for your falling down and failures. Because we keep, it's like somebody who touches the stove, you're embracing the stove now. Mm-hmm. You're embracing it. You know it burns, it's going to burn you, but I don't know what it is. You still fall back and make the wrong choice.
And Judge, while the state did offer them the minimum 5, and we definitely appreciate that offer, his only chance of continuing to be on probation is with you, and with the decision, whatever decision that you make is his one chance of that. And that's why he wanted to come to you directly to give him that shot. And then my last witness, it's going to be long, is his mom. I don't know if Mr. Coleman has any cross-examination for him.
I don't have any cross-examination. State would like to be heard at some point, Judge.
You get a chance. And I'm only going to ask you 2 questions, and I want you to give you a narrative response as best you possibly can. And here's the first question. First, go to state your full name, introduce yourself.
Raise your hand. First of all, you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God.
State your full name for the record and introduce yourself to the judge.
Hi, Judge. We talked the last time we were here.
Yes, ma'am.
Barbara Falk, Colton's mother.
Yes, ma'am.
So you remember talking to the judge the last time?
We talked after court was over at some great length.
Okay. All right. My one question for you is this. You love your son, you care for your son, you understand that Judge Stevens can make a decision to continue him on probation. You understand that, right? Yes. So in your own words, without me leading you, I want you to say whatever comes to your heart. Talk to Judge Stevens as to why you're asking him to continue this up on probation. Look at him and tell him what you want to say. Go ahead.
Colton's dad, we've been divorced for years, is not doing well. If Colton goes to jail, I don't think his dad will live till he gets out.
Yeah, our life.
There's not a love.
Our life touches
lost.
others. We don't live by ourselves on this planet. Our life touches other people's lives. What we do affects other people, not just us.
Right. But I mean, his boys need him. Like I'm retired. I was never thinking I was going to start over again raising kids, which I love my grandsons. They've got new bedrooms, new bikes. They got their school clothes, their school supplies. I'm ready. And they're happy to be where they're at. They love their granny. I get them in the kitchen. They help me cook.
Well, you use a father. Just a responsible father.
They do need their dad.
Not big. Need a dad that is consistent on bad role modeling and bad examples. Right? Yes. All your choices. Got too many people relying on you. You don't live on this planet by yourself. You have responsibilities, but you have to act responsibly. Okay.
So what I'm hearing you saying is that, and I'll be quiet, is that if he's revoked, that impacts not only you, the children, his dad who may be dying, family members, himself. He's gainfully employed. So at the end of the day, with all that being said, in your heart and your soul, are you asking judge to keep him on probation?
I am.
Judge, I don't have any other questions. I don't know what Mr. Coleman asked.
Yeah, but you don't have anything, do you?
No.
Okay. Ma'am, just please have a seat. Thank you. Anything else?
Judge, I think I kind of summed it up.
I understand what your position is.
And I'm just asking if he's asking to continue the supervision.
Okay. From prosecution.
Your Honor, inevitably, when we get to this point in these types of cases, these MTRPs, there are a number of advocates for the defendant. You've got Mr. Adams here who's advocating on his behalf. You've got his mom who's advocating on his behalf. I, Judge, stand before you today to advocate for a Mr. Manuel Gaspar Jr. You know who Manuel Gaspar Jr. was? He was a 71-year-old disabled veteran who walked with the assistance of a cane that this defendant pushed down at an ATM and stole his $300. That's the underlying offense, the circumstances for which this defendant was placed on aggravated robbery, deferred adjudication probation, Judge. I'm here to advocate for Mr. Gaspard. I would venture to guess what Mr. Gaspard would say about all of this business about a second chance, third chance, fourth chance, blaming everyone except taking responsibility and taking that 5-year offer that I offered to this defendant, which, by the way, is the minimum, which, by the way, was predicated upon this defendant walking in here, accepting responsibility, taking that punishment, and not putting the state and through this hearing, and for that matter, his mom through this hearing, Judge. We would ask that on behalf of Manuel Gaspar Jr., 71-year-old disabled veteran, that you revoke this defendant's probation, reform the judgment, and send him to TDCJ where he's earned every bit of it. Thank you, Judge.
What are you asking for?
Judge, the 5 years was, again, predicated upon him accepting responsibility and not putting us through a contested hearing. I would ask for something more than 5 years. And of course, that's within the discretion of the court.
Judge, nothing's changed. Notice what he said. It's predicated upon him accepting responsibility. Every allegation you asked him about, he said true. So if that's the argument they make, then follow it to his logical conclusion. He did accept responsibility. The reason that we didn't take the 5-year offer is that you are our only hope of continuing on probation, and that's why I brought him.
At the end of that's incorrect.
Well, he is, but you.
He is in control of his destiny, really, not me.
Right. And so what we were asking is based upon what you heard him say, based upon what you heard the mother say, and accomplishments that he's made, Judge, we're asking you to give him one final shot. Absolutely one. But he did accept responsibility because he told you true to everything. Everything he said true to.
Anything else? Anything from the defendant?
No, is there anything else you want to tell him that I missed?
You haven't missed anything. You've done an outstanding job. I know that I messed up, and I am just asking you for one more chance.
And there's consequences for everybody. So you do well, you're rewarded. You do poorly, you get punished. It's the way it is supposed to be. Or it wouldn't be fair for the people who do well. Doing well would not be something important and good and genuine. Rewarding. Anything else?
Judge, we're just asking the mercy of the court on that.
Anything else?
No.
All right. Okay. And then it's before me.
Yes, sir.
Nobody else. The court is going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by preponderance of the evidence or greater, as allegations 1, 3, and 4 are proven true, as the defendant has voluntarily, knowingly, intelligently, based upon advice from counsel, admitted to those 3 violations. Only one is sufficient, but the court finds that those three are proven true by a preponderance of the evidence or greater, and this motion to revoke unadjudicated probation is hereby granted. Earlier in this case, sir, you had pleaded guilty to the first-degree felony of aggravated robbery voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit, and it's almost 500 days you've served toward the satisfaction of that sentence. And it can't go without noting that the essence of this crime was committed on a disabled veteran, 71 years of age at the time. And there is the video at Chase Bank, which shows which shows you entering the bank, and that Mr. Gaspard, the victim, is there first. You came afterwards. He is walking with a cane at 71 years of age and being disabled. You enter, and as the victim is retrieving $300 from the ATM, you used your body to push him out of the way while grabbing the money. And then Mr. Gaspard fell against the glass wall of the kiosk. You fled on foot, and the victim can be seen slowly walking to the kiosk door and using the assistance of the wall to help balance him. And well, that is a terrible set of facts for somebody who's telling me about how selfless he is and dealing with his family. And this is an aggravated case, and you're being held responsible. And you're being held responsible in spite of what you're telling me. You know, you have dependents at home who rely on you and need you. And you speak all the good things, but you're here on this motion, a second file motion to revoke probation, not submitting to alcohol and drug screening on numerous occasions where the probation office was trying to help you, not successfully completing the drug intervention program, and not entering the anger management programs, and not long ago, you pleaded true to two criminal mischiefs, a family assault, and illegal possession of cocaine and amphetamine. It's more than enough to hold you accountable this is all while on probation, when you knew one violation is enough. The court finds that this decision, the other court, is in the best interest of justice based upon the circumstances of this offense. And the court is under these circumstances that we're talking about is a light sentence. Gives you the some time to serve, and then when you were released, you get to go back to your family. But I'm feeling sorry for the kids, but certainly for the victims. a disabled veteran who deserves respect. Trauma. That is all.
Thank you, Judge.
Thank you, Judge.
So, Deanna,
Hey, Judge, you couldn't do Elam next time. What's the she was the most fun. 5 years since after a while.
is it Roderick Elam?
He's available.
That's you?
Yes, sir.
Judge. The Roderick Elam? Is that you? You got 2 cases? Correct?
Yes, sir.
What are we doing?
Yes, we pled. We sent the paperwork.
So plea on the burglary, Judge, and dismissal.
I'll need the fingerprint.
Just get fingerprinted.
You're welcome.
This is
Just
18.
Yeah.
10:56 is going to be dismissed.
Yes, Your Honor, I believe I sent that on.
Okay.
Stuff you off? You swear or have to tell the truth, the whole truth, and you can represent the truth. Okay. Is it right here? All right. You get
We call 25 CR 1897, the state of Texas versus LaRoderick Elam. That's you?
Yes, sir.
Present with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary? Yes?
Yes, sir.
In summary, this indictment alleges that on or about November 11th, 2025 in Jefferson County, Texas, you committed the 2nd-degree felony of burglary of a habitation. Do you understand what you're charged with?
Yes, sir.
This is a 2nd-degree felony, which means you face no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Yes.
Yes, sir.
Okay. An agreement's been reached where you would be pleading guilty, not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length. And another case will be dismissed, 25 CR 1056. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Yes.
You're pleading guilty voluntarily. That is on your own free will. And because you are guilty. Yes.
Yes, sir.
That's a question. Are you on your own free will and because you're guilty?
Yes, sir.
Okay. Show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered?
No objection.
Without objection admitted. The states you are mentally competent. Enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with representation by your lawyer. All true. So help you God.
Sir.
All of this is true. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I will follow this agreement. I'm going to find that you are pleading guilty voluntarily. You are mentally competent to do so. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow this. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 20 years in prison. You don't want that, do you? No. There is no restitution, I guess, right?
That's correct, yes.
Okay, you're going to see the probation officer. There's one other case, 25 CR 1056 will be dismissed as part of this agreement. Do you understand, sir, what has happened today?
Yes, sir.
All right, please see the probation officer. Thank you.
Can we do Henry next, Judge?
If I can get the pad open.
That's not what we do.
It is, oh, just so awesome.
Yes, you're right.
Yeah.
Okay, that's not a problem.
Anyways,
Okay, who is it?
This is Mr. Henry. There are
One case.
yes, it's one, it's an MTRP judge. We did get an offer in that case. My only concern with that.
But you didn't accept it.
No, well, here's the problem.
No, we didn't.
I did, well, that's correct, I didn't, but he's correct about that. But there's a reason why. And the reason why right now, Judge, is that in looking at the basis of the MTRP, the first allegation is an unlawful possession of a firearm, and that would be by felon, right? If I felt. To my understanding, their cases should be coming. I'm just told might know more than I will when that case is coming out. But I did not want him to move him on the MTRP, and he got another case coming out the pipe. Has it already been filed?
I don't know. I
I mean,
don't have it. Just I don't have it.
right. He has a new case. That's the
Lawful possession.
because he's saying it hadn't been filed yet.
I saw how to say it's rejected.
Well, that's good news for us.
But the DWI was filed on 4/23.
I don't have that yet, the DWI. But I don't believe
It was
that.
rejected on 7.
Like, but I don't believe the DWI is a basis for the M202, but
It's part of the First Amendment.
Oh, okay. So let me get the DWI information first.
What are we going to do today? Do we do something today, or are you going to reset this?
Reset this one, Judge.
Oh, okay. That's right.
Reset it.
1 week?
Judge,
What?
I
He's not
suspect,
going anywhere.
I know that. I suspect we're waiting on a lab on the DWI. That takes some time, Judge, but it's certainly up to the court's discretion as far as the length of the research.
Yeah, it is, but you aren't ready right now.
No, because I mean.
Well, he says it's not ready, so what can we do? I'm going to reset it 1 week to see what the status is, okay, on things?
Okay, that's fine. That's cool.
That's all I can do, folks.
That's fine.
What's next?
I think the lab is gonna be a little bit right.
I said a Salgiana. What are we gonna do? I have a. I don't know what I have on this. I don't have a disposition on it.
No, if he agrees, maybe wasn't.
And this is a new indictment. 3rd-degree felony of unlawful possession of a firearm by a felon. Let's see. Yeah. What do you want to do today on this?
On this one, he's saying that he did not possess that firearm.
Let's see.
We did.
Yeah, we can hear him out. That's on Saul. I think he has a misdemeanor too, right? Yeah.
I don't know.
And we did get an alternate case.
Here's the deal. I want you to take a look at this. Just so you know, I'm not posturing or here.
He's got 4 convictions of DWI.
That's exactly what I was about to point out, Judge. And I think 2 of them are sequenced and very well maybe could get into habitual. My offer is open only today only. Either he takes the 8 or he rolls the dice on being potentially upgraded to or enhanced to habitual.
There was is this his car? I guess. There's a Taurus in the glove compartment of the vehicle.
May I want to talk to him?
No. All right. So what are we doing today? Nothing.
So he's all right. He's saying that after the day he's going to pull this off. I'll tell him one more time, but I was doing the rest of these.
Edric Gross.
That should be done.
I got 4 cases.
You got 5. Yeah, I sent the paper. Me and Mr. Helm sent that to you.
Okay. It's like 3 pleas and 2 dismissals.
That's it.
All right, let's see. We're going to do.
The offer stopped to pay the fee. You don't know, I will get to see it.
28, 29, and 30 are dismissals. Does he need to go in front of you? Go in front of that lady. She's going to swear you in, sir.
Just your right hand, you swear or confess the truth, all truth, and nothing but the truth, so be God. Okay, under your right hand, trust. Langston. Did you stop paperwork for you?
Yeah. Did I say that to you?
Yes, my good chair. You said something.
I didn't. I thought I did.
I think you need to.
Is it in the little photo thing?
I feel like I signed it already. I'm just going to
Hold on, sir.
Next year.
We got 5 cases, 2 of which are going to be dismissed. You are Edric Elijah Gross, present with your attorney, Mr. Adamson, state's attorney. Does the defendant waive formal readings of these indictments and arraignments here? Can we proceed into summary?
Yes, sir.
In 26 CR 626, in summary, this indictment alleges that on or about March 11, 2026 in Jefferson County, Texas, you committed the first-degree felony of aggravated robbery. Do you understand what you are charged with here, sir? It's yes or no? You understand what you're charged with? You have to speak out so that she has to hear you. Okay. You're facing a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? You have to speak.
Speak up. You got to speak up. No, you're not getting a 10. He's giving you the range.
That's what you could get.
Right.
We're telling you what's possible. Do you understand what's possible here?
Yes.
There's an agreement that's been reached. You would be pleading guilty, sentenced to 10 years in prison to run concurrently with 2 other cases, and 2 cases will be dismissed. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty? Guilty or not guilty?
Guilty.
Guilty. Are you pleading guilty voluntarily and because you are guilty? Yes. Are you pleading guilty voluntarily?
Voluntarily.
And because you're guilty?
Yes.
All right. I show you what's marked as State's Exhibit 1. Did you sign that?
Did you sign?
Understand it? Discuss it with your attorney. Are the contents true and correct?
Yes.
State's Exhibit 1 tendered without objection?
No objection.
Admitted. This states you're mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your right to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. True?
True.
All right. And again, this states that on or about March 11th, 2026 in Jefferson County, Texas, you committed the first-degree felony of aggravated robbery and stabbed the victim and threatened him and placed him in fear of imminent bodily injury or death, and you used and exhibited a deadly weapon, namely a knife, in the commission of this robbery. Is all of this true, so help you God? Yes. An agreement has been reached where you would be found guilty, sentenced to 10 years in prison. Is that your understanding?
Yes.
If I'm going to follow this, you have no right of appeal. Do you understand? Anything else to add here?
Nothing.
If not, I'm going to find, sir, you were pleading guilty voluntarily to this aggravated robbery. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a knife, was used in the commission of this offense. Do you understand what has happened here today, sir, in this case?
Yes.
All right. Next is 26 CR 627. Does the defendant waive a formal reading of this? Can we proceed in summary? When this indictment.
Yes, sir.
And we're going to take this one and 26 CR 628 together since this occurred on the same day. On or about March 11th, 2026. Can we take these together?
Yes, sir.
In summary, each of these two cases, 26 CR 627 and 628, similarly allege that on or about March 11th, 2026 in Jefferson County, Texas, you, Edric Elijah Gross, in 26 CR 627, committed the state jail felony of terroristic threat against a peace officer by threatening to commit an offense of violence, namely aggravated assault. And the victim was a peace officer of the Beaumont Police Department. You understand what you're charged with there?
Yes, sir.
And in 26 CR 628, this goes on to allege that also on or about March 11th, 2026 in Jefferson County, Texas, you fled, you committed evading arrest or detention by fleeing from a person you knew was a peace officer who was attempting lawfully to arrest or detain you. And paragraph 2 goes on to allege that you have 2 or more prior convictions of evading arrest or detention. One in 2019 out of County Court of Law 2 of Jefferson County, Texas, and the other on or about April 22nd, 2025 out of the 252nd District Court of Jefferson County, Texas. Paragraphs 1 and 2 of this indictment constitute a state jail felony as well as in the immediately previous indictment of terroristic threat that we reviewed with you in 26 CR 627. Each of these cases means because these are state jail felonies, if convicted, you face confinement in a state jail felony for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Agreements have been reached where you would be pleading guilty and sentenced to 1 year in the state jail in each case.
Yes, sir, on the state jail. Yes, sir.
I'm a circle years here.
Thank you, Judge.
And these would run concurrently. So you would be sentenced to 1 year state jail in each of these two cases. Is that your understanding of the plan? If I follow these agreements, you have no right of appeal of your cases. Do you understand? Yes. And how do you plead in each of these cases of these state jail felonies? First of all, 627 terroristic threat against a peace officer. Is that true? Are you pleading guilty to that voluntarily and because you are guilty? Yes. And in 26 CR 628, the evading arrest or detention, are you and the 2 prior convictions of evading arrest, are you guilty of those allegations? And are you pleading guilty voluntarily and because you are guilty?
Yes. Yes.
Yes or no, sir?
Yes.
You have to speak out so she can hear you because you have a soft voice.
Okay. Okay. Sorry. I thought that 13 minutes. I know it's
I can show you what's marked as States Exhibit 1 in each of these cases. Did you sign those documents, understand them, discuss them with your attorney, or the contents true and correct? Yes. States Exhibit 1 tendered into evidence without objection admitted.
No objections.
Okay, this state in each of these 2 state jail felonies that you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You understand what you're charged with. You're guilty of the crimes and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. Yeah. Correct. States Exhibit 1 made a part of the record in each of these 2 cases. Anything else to add?
Nothing.
If nothing further in each of these 2 cases, in 26 CR 627 and 628, I find that the defendant has pleaded guilty voluntarily. He's mentally competent to do so. He understands and appreciates the consequences of pleading guilty. There's sufficient evidence supporting his guilty plea in each of these 2 cases to find him guilty beyond a reasonable doubt. I find you guilty beyond a reasonable doubt of this state jail felony of terroristic threat against a peace officer in 627. You were hereby sentenced to confinement in the state jail for a term of 2 years. No, I'm sorry, state jail for a term of 1 year.
Yes, sir.
And in cause number 26 CR 628, you have pleaded guilty and true respectively to paragraphs 1 and 2 constituting the state jail felony of evading arrest or detention with prior evading arrest or detention convictions. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from States Exhibit 1 admitted in this case. And that is enough to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony. In this case, I'm following this agreement. You were hereby sentenced to confinement in the state jail for a period of 1 year on this case. All of these sentences shall run concurrently.
Yes, sir.
Do you understand what has happened today, Seth? On these 3 cases. All right, good luck to you. I have 2 dismissals on Mr. Grove.
Yes, sir.
26 CR 689. And that dismissal is granted. And 26 CR 628 and 629, both of those cases are hereby.
Yeah, you take it.
Langston.
Golden.
Who's it?
Jones.
Dismiss.
Jones.
No, I need it. Not beyond. Thank you.
I'm sorry.
I said they told them
26 CR 629 and 630. Those 2 cases on Edward Cross. Here's kind of dismissed on this day, and he is found guilty and sentenced on the cases of 26 CR 626, 627, and 628. Okay. That's steady gross. Jordan Jones.
Yes, sir.
Here's the other one. What are we doing with Jordan Jones?
Judge, on Mr. Jones, is to my understanding that on the first allegation of the assault, the complaining witness has gone to the DA's office and filed an affidavit of non-prosecution.
Judge, I haven't seen that. That may be the case, but the state has every intention of going forward.
And then, that's what I mean.
We've got two other things, failing to provide community service and failing to pay court assessed fees.
He's denying those, Judge.
Okay. So
And then,
we'll have a hearing on that.
we got it.
So
Right.
what are we going to do? Let's put those aside for a second. What are we going to do on? Jordan Jones, that's the other MTRP. He's got two MPRPs?
He has three cases that he got put on probation for, Judge, and it's the same underlying violations. And like I said, to my understanding, the complainant does not want to go forward, and she put it to DA's office.
What are we going to do on Jason Young?
That's a plea. Send it to, that's
Okay, let's go. Let's get Jason Young and just put him aside for just a second.
That's done.
Because after that.
He sent it to you. I had that one.
What are we doing with Christopher Chandler? Is that yours?
But the one Young, I think he's out there now.
I do have.
That is totally done.
603. 24 CR 603.
Yeah, I signed him up with you. Here's the young right here. Start wears down.
Please sign over there in front of that lady.
This one.
Raise your right hand. Square or.
Okay, you're on this one?
Yes,
We got a problem right off the bat.
Oh, it's a first degree. I did see
Is it
that.
first degree? Okay. It's been checked off as a second degree. So you're on the police paper, so we're gonna fix that, okay?
Yes, sir.
It's a first degree felony, right, everybody?
That's correct.
That's what it says in the indictment, isn't it? Okay, 24 CR 603 is called. You're Jason Paul Young?
Yes, sir.
Present with your attorney, Mr. Adams, and the state's attorney. As the defendant, we have a formal reading of this indictment and arraignment. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about December 20th, 2023 in Jefferson County, Texas, you committed the first degree felony of aggravated assault against a security officer. Namely, you used a deadly weapon, namely a firearm. And do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty?
Yeah.
Voluntarily, that is on your own free will.
Yes, sir.
And because you are guilty.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign this? Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered. Without objection admitted. This states you mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
I will follow this agreement. I'm going to find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first degree felony of aggravated assault against a security officer with using or exhibiting a deadly weapon, namely a firearm. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. And there will be an affirmative finding on the judgment that a deadly weapon, namely a firearm, was used in the commission of this offense. And this will run concurrently with other cases. Do you understand what has happened today, sir?
Yes, sir.
Anything else? That is all.
Back up.
He was asking about, I think he had, how many years he had?
2 years and 7 months.
2 years, 7 months that he's already set.
There's nothing I can do. I'm not the one that makes that decision. That's for the prison authorities. They're in charge of determining that. You get credit for all time you've served in accordance with a case. Yeah.
To see if you had a hold on Judge, that's what I can do.
But yeah, we're not the ones who discern. That's the parole authorities. They make all those decisions, but they have all the data. They have the data, same data we have. Yeah. We're just not, we don't have the authority to grant it because sometimes they take away parole credit if you've done badly in prison, and that's not anything we know about.
Right.
Okay.
I think that's all the ones I could.
I have Jordan Jones.
Oh, that's gonna be a.
What are we gonna do on Jordan?
That's gonna be a contested hearing.
Yeah, we'll set it for hearing, Judge.
Let's set it up for hearing.
Okay, here's Saul.
I mean, I've been sitting there all this time.
Oh, yeah, Saul. So they said it. What do you want to do with Saul?
Well,
It's the dates off the table today. If you're gonna take.
I asked him right now, see me sit. Let me get him out.
All right, Sal, we need Sal Gayonis to see if he's the last one. Maybe he'll take a deal or not. We can get a deal and then we're through with the day for the day.
That is it.
So I will email, reach out.
Looking at the
I six.